if it might admitted, but thereafter matter has not been listed, my lord. There is an IA for say, my lord. We are judgment that in that way execution will be started, my lord. So the matter may be listed on
It was admitted when?
in the month of December 2023, my thereafter matter has not been
Okay, we'll have it next week.
on witness them, next witness obliged.
My lordship, I beg to mention one RSA for listing for tomorrow in the lordship.
Fresh matter.
Yes, sir, lordship, the respondent is taking steps to execute your lordship.
When did you file?
Lordship, I have filed it on. I have the serial number, your lordship,
When was it filed?
day before. Because
If it comes, we don't have, but civil matters, as you know, it has to be checked. It may be, there may be some defects. We don't have any issue. We can have it tomorrow.
obliged, sir.
May I beg to mention the listing a old matter, 2018 matter, CRP IO, sir. Hearing matter, sir. Earlier it was listed,
It will not
It
come
is-
for hearing, it will come for orders. We'll fix for hearing. Have it on Monday next.
my
Lordship, I beg to mention item number 10. Lordship, the senior counsel, Mr. Secretary Process, is going to attend his father's date, and we have taken custom from the
Okay, we'll have it on Friday next. Okay,
next week.
prayer for adjournment has been made on behalf of 3 A.K. Purkash Learned Counsel for the respondents on some personal grounds, full stop para. List on next Friday. Friday. 14th. 14th.
It is 2012 matter. So can it be on?
RSA.
Yes, but can it be on Tuesday or? The hearing
Tuesday have
day?
fixed many matters, but we can have it.
If it reaches, apply.
May I please, Your Honor? My lord, I beg to mention for a listing of a CRP IO, my
Fresh matter.
no, my lord, 2022 matter, my lord. In this case, my lord, I am the decree holder. In the title execution case has been stayed, my lord.
Okay, when was it last listed?
My lord,
When was it last listed?
22 for 2024, my lord. That day, my lord, not heard, my
Now, was any orders passed on that day?
no, my lord. Only passed the list after 2 weeks. Yes, sir.
List after 2 weeks. 2 weeks is over.
Yes, my lord.
22. Okay, we'll have it on next Wednesday.
Most of it.
I beg to mention listing IA.
IA4?
IA for stay for judgment and order. RSA already admitted.
When have you filed the IA?
4/6/2020.
And RSA is of which year?
24. Kindly pick for next.
IA has been filed subsequently.
Lordship.
When did you file the IA?
File 4/6/24.
2 days back.
Lordship.
Okay, Wednesday next.
Obliged.
May I please, Your Lordship, I beg to mention item number 5. Your Lordship, due to the serious medical conditions, the learned English counsel has gone to the forfeiture to attend his father's medical condition.
Who's going?
And alarm.
An alarm, okay. 13th matter, okay. Personal difficulty. You are for the other side.
Sir, we have taken the
Okay,
At night, please call me.
okay. Personal difficulty. Okay. Some days, we'll have it on Monday next.
Lordship, Monday problem. So 4 weeks time may be granted for,
Why?
because in the midst also he has some problem. That is why in there be.
After 2 weeks, my lord.
These are 13 matters.
Yes.
We cannot grant like this.
At best, after 2 weeks.
10 years have passed.
Your Lordship, in the first week of
First week of?
July.
We'll have in vacations that time. We do not come.
4 weeks time may be, because
Oh, we are not granting
in
4
the
weeks.
midst, Your Lordship, in the midst,
You make alternative arrangement, Mr. Counsel.
Yes.
Is there personal difficulty for today? We are accommodating. 13 matter, do you expect that 4 weeks time will be granted?
We have also mentioned the effort, but due to medical conditions,
We are accommodating you today. We'll have it on next Thursday.
Thursday,
You make some alternative arrangement. We do not know. 13 matter, we cannot adjourn like this. Your problem is not that important. Problem of pendency is much more important. Your problem we have taken for care for today.
Your Lordship, if
A
the
prayer for adjournment has been made on behalf of the respondent on personal reasons. Full stop. Para. Considering that this RSA is of the year 2013, comma, though a slight accommodation is granted for today, full stop. The matter is accordingly directed to be listed on Thursday next. Yes, next Thursday.
Thursday, Lord's counsel will not be available.
We do not know. We'll go ahead, make some alternative
Any
arrangement.
other date, Your Lordship, any other,
Friday.
any other in the next week after Eid? After 23 or 24?
17 is there.
17 Eid is there, 24, 25.
On 13th,
13.
13th, next Thursday.
Oblige.
Yes,
May it please, Lordship. Lordship, I beg to mention item number 8.
yes.
Lordship may adjourn the matter today and fix it in the next week.
Where are you
If
seeking
I ha-
adjournment?
I have objection for this sort. So it is a matter of 2017 lordship, but we are plaintiffs and both the courts cited in our paper.
Where are you seeking adjournment?
Lordship, I could not complete reading the brief, Lordship.
That is not a good enough
Yes.
Lordship,
ground.
it may be taken
Very
up on
simple.
Tuesday, Lordship.
Very simple matter, lordship. Only on the basis of Amin commission, my.
On Monday
recovery-
next, Monday next.
Sure.
A prayer for adjournment has been made on behalf of the appellant, which however is objected to by the learned counsel for the respondents. Full stop. Para. In the interest of justice, list a short accommodation is granted, directing listing of this matter on Monday.
Monday or hearing date, lordship, Tuesday.
Monday we'll try.
Obliged, Lordship.
I just mention item number 9.
Hmm.
He is appearing for the claimant money in this matter.
Hmm.
There are two cases. The one has been listed in court number 19 today, item 1 million. And arising out of the same judgment. So may I pay both the matter may be taken up together. Same judgment of same party.
Now, what orders do you expect us to pass?
No, my lord, that has been tagged with this matter.
Understood, but that matter, if it is taken today, how can we direct?
No, after few days, my lord, any date, my lord, both the
Now,
matter-
what has happened to that matter?
that matter has been tagged with this,
Has been tagged already.
Yes.
Orders have been
my
passed.
lord.
Okay. It is submitted that there is another analogous appeal being MSC appeal number
180 of 2019.
180 of 2019. Full stop list. Along with the said MSC appeal 180 of 2019 after a week.
My lord.
This will be a 9.
Item 9.
Okay.
Oblige.
What I beg to mention for listing a matter appeal, lordship, in this matter, I am for a respondent, lordship. Challenging the order of the learned trial court, the husband appellant has filed this matter appeal, challenging the amount of permanent alimony, lordship. I am for a respondent, lordship. Next week, any lordship, for that.
When was it filed?
Lordship, the appeal, lordship,
Yes,
in 2019, lord,
19.
19,
You have appeared.
lordship, you have appeared.
There is a stay order.
Lordship, no stay order, lord.
Then,
I am for a respondent, lordship.
if there is no stay order, why are you so? What is your problem?
Lordship, the amount that has been granted by the learned trial court for that reason.
They are aggrieved. You are not aggrieved.
They are agreed, lord.
They are aggrieved. There is no stay order.
Lord, no stay order.
So, where is the urgency? If they mention it's a different matter, we don't have a stay order, can they adjudicate? What is your difficulty?
Lord. Oblige. you.
I didn't want to open this. None appears for the parties on call. For the appellant on call. Para. This second appeal is of the year 2008 and the title suit is of the year 1997. Full stop. Para. Be that as it may, and in the interest of justice, a further opportunity is granted to the appellant to be represented. Full stop. List on Monday next. Full stop. It is however made clear that in case of further non-representation, this court would pass appropriate orders. Adding to 2008 matter. Yes.
May I please? My lord,
Who is your senior?
Yes.
SP Chaudhary. Okay, call him after a while. What is the matter?
my lord, this is judgment of reversal, my lord.
You're the plaintiff.
I am the defendant, my lord.
Okay,
The
it
suit
was
was-
dismissed
Suit was
initially.
dismissed against that appeal preferred, appeal allowed.
First
Only
appellate court allowed the
Uh,
suit.
suit, my lord. Suit was decreed. Only one
Suit for?
substance. My lord,
Suit for?
suit for, my lord, ejectment. Basically, it is a suit for ejectment. And also for declaration of the right title. But the court, both the court held that I am not the tenant. But the trial court comes to a finding that I failed to prove, I have established
It is
The-
not a tenancy matter.
not a tenancy matter.
Okay.
So,
Therefore, a second appeal.
yes, with regard to adverse possession, trial court held that this title is adverse. So therefore the dismissed suit was dismissed, but
What was your defense?
the defense, my lord, my case is that, my lord, in the year 1958-59,
Hmm.
the defendants
Did
committed.
you plead adverse possession? Did you prove adverse possession?
I have pleaded in my WS as well as by the evidence, oral evidence, as well as there are some of the documents are exhibited to
Regarding adverse possession.
adverse possession.
And on that basis, the suit was dismissed.
Suit was dismissed. But
And
appellate-
what was the finding of the first appellate court
first appellate
on
court,
this issue of
adverse possession.
adverse possession?
But first appellate court comes to a finding that the title of the plaintiff is proved because he has purchased it from by a sale date.
Yes, that is different.
That is, but with regard to adverse possession, the trial court finding it perverse by saying that, my lord, with regard to tenancy and all this, although it is affirmed, but the first appellate court want to say that the evidence is not sufficient to prove that there is a adverse possession,
On insufficiency.
insufficiency of evidence.
Okay. Yes, please call your senior. We'll have it after a while.
No, please, your lordship. Lordship, it's a concurrent finding. I am the plaintiff earlier, and I pray for right title, interest, and cash possession. Then, by order dated 17/7/2015, Munship number 2, Hailagandhin, title suit number 87 of 2010.
You are praying for early hearing.
Yes, my lord. It's
Suit is of which year?
16 matter, my lord. And
Suit is of which year?
suit. Title suit. Suit was 2010, and it
Okay,
was
we'll have this for hearing. When do you want?
on Wednesday, my lord. It was.
Wednesday hearing, it may not be possible.
Then, my lord, 18.
We'll have it on 18th. 18th is okay for you?
The matter is stayed, my lord, by this honorable court.
Now tell us a date of your consensus. We'll fix it.
Huh?
We'll have it on 20,
20.
20. 20.
Highly applaud.
Your name?
AK Hanan. I'm appearing on behalf of MJ Khan. My name is not there.
On behalf of
MJ Kadir.
Heard Sri A.K. Hannan, learned counsel appearing on instruction of Sri M.J. Kadir, learned counsel for the applicant appellant, who by means of this application has prayed for early hearing of the connected RSA number 135 of 2016. Full stop para. Also heard Sri J. Laskar, learned counsel for the respondents. Full stop para.
My lord, I'm from the respondent.
In the IA, we are saying.
Yes, I'm the applicant.
Yeah, also heard Sri J. Laskar, learned counsel for the opposite party. Para. Considering that this RSA is of the year 2016, the instant IA is allowed, directing listing of the records have come,
Yes.
directing listing of the connected RSA 135 of 2016 for hearing on, we'll have it on 2020.
Highly obliged.
Bisway, huh? I stands disposed of.
Item 16, subpoenas.
My appeal. My lord, this case is for restoration of a matrimonial appeal, my lord. That, my lord, the petitioner is not aware that her case has been dismissed for default. My lord, she was sitting, my lord, on good faith. She was sitting there in my lord,
Who is for the respondent?
the other side.
DK made they were, objection has come.
My lord,
on
perhaps it
record.
is come. Yesterday they have filed. The day before yesterday.
Yes, so can you call them?
My
Since
lord,
there is an objection,
Lord, I do not have their phone number.
names are reflected. If they are not there, we'll go ahead.
My lord, AK Kapoti is there. I am with
They have taken the ground of delay.
my lord.
What is your answer?
My lord, delay because that is the delay is because of communication gap, my lord.
No, we are not on explanation of the delay. What is your answer? Have you given any explanation?
My lord, I have given the explanation that communication of delay, my lord.
Where?
That, my lord, on
Paragraph
paragraph 3, my lord.
3 of the IA.
3 of the IM, my lord.
Please read.
Please, 4, my lord.
Okay. You are the wife.
I'm the wife, and I have been newly engaged, my lord.
No, yeah, in the matrimonial case, what had happened? Who had
My
instituted?
lord, matrimonial, my lord, divorce has been, my lord, allowed.
You had filed the divorce petition.
My husband filed, my lord.
Husband had filed.
Husband filed, and my lord, the honorable court, the learned court leader has.
You are challenging the decree of divorce in this appeal.
In my lord, in this appeal.
Okay.
Just, my lord, may I just, my lord, throw your lordship kindness as to regard it, my lord, that is done. There is an order, my lord.
What were the grounds of divorce?
That is, my lord, that the ground of cruelty and, my lord, dejection. But for the first time, I have found, my lord, cruelty. They have observed, given the observation of cruelty against the wife.
Why not? What first time? What are you saying? There have been numerous cases.
My,
Cruelty is not necessarily from the husband's side.
yes, ma'am. That is that.
So why are you saying first time? You don't read law reports.
Hmm.
It
And
seems you
dejection-
don't read.
And my lord, Dijaskon, so far Dijaskon is concerned, my lord, as on today, they are living in the same house. And my lord, regarding to my lord, out this, my lord, wife from their house, they have also filed a complaint case before the Lanark court below. That copy I have in possession. And just for a moment, I would like to call your lordship kind attention, my lord.
No,
Page
let him,
11.
let him come,
Yes, my lord. My lord, 11, page 11, just for a moment. my lord.
try to locate him.
Ma'am.
Look at the council.
My lord, one significant fact hearing is that, my lord, that the alimony has not been paid. Alimony has been paid, and during this, my lord, while the case was pending, my lord, the Lanark court has given direction that, my lord, the opposite party can issue a, my lord, handed over the stake to the council of this wife, my lord. And, my lord, 1,20,000 and something. My lord, that amount has not been handed over to the, my lord, wife.
Who has not handed over?
My lord, that the engaged council, my lord.
Have you lodged any complaint before the bar council?
That I have not lost, my lord.
Then we are not here to adjudicate those matters.
Anyway, my lord.
You lodge a complaint, you may be correct in contending.
Yes.
You lodge a complaint.
Right.
You try to have the council, will try to restore your application.
My lord.
Okay.
Obliged.
DK Medhi, A Kakoti, S Bora.
A Kakoti is there, my lord. A Kakoti. S Medhi is the
DK Medhi, I think last time DK Medhi was there. DK Medhi or DJ Medhi, I don't know. Okay, try to bring him.
my lord.
Yes, Mr. Gupta.
But in this case, side order dated 15/9/2008. The substance
You are
of
the appellant is the
dependent. Dependents.
suit for,
Dependents in the
suit for,
suit for my lord, declaration of right title interest and for ejectment.
yes.
But the substantial portion of framed on 15/9/2008 matter. That is only one substantial question of law, 15/9/2008. Whether the finding
Yes, please.
whether the finding of the learned appellate court below with regard to the plea of adverse position is purpose to the material of record.
Yes, that is the
That is the substance question. My lord, plain it at page 42, my
42.
42.
Yes, please.
But I'm not reading the entire print, only the relevant portion which are required.
Yes, yes.
My lord, lordship may kindly come to page 45.
Yes.
Page 45.
Hmm.
Second paragraph. Premsukh Agarwala
Hmm.
and Anantram Agarwala and Vijay Kumar Agarwala on 2/1/1984 by a cell deed dated 2/1/1984 and registered on 3/1/1984. The registered deed number 11 of 1984 of the sub-registrars of the Tinsukia, district Tinsukia, Assam, sold the said land with extending houses thereon to the plaintiff for valuable consideration and duly delivered possession thereof to the plaintiff. The sale deed was executed on 2/1/1984 by the legal heirs of Duli Chand Agarwal.
Why there are 3 dates are there and 1 deed number?
Sale deed is 2/1/84. It
No,
was
no.
registered on 3/1/84.
No, please read whatever you have read in the second paragraph.
Premsukh Agarwala with Anantaram Agarwala and Vijay
3
Kumar.
persons
3 persons.
on 2/1/84 via sale deed dated 2/1/84.
Yes.
registered on
on
3184.
3184. The registered deed number is 11 of 19.
Acha, it is a common deed, common one land.
One
They are the joint owners.
they are the joint. They are the legal heirs of Dulit and Agarwal.
Okay. Sale deed number 11 of
11
84.
of 1984.
Where
Regist-
plaintiff claims to have purchased certain lands from 3 vendors.
Yes, my lord, 3 vendors.
Hmm. Okay, then,
But by virtue of this sale deed, they claim to be the owner of this suit land.
okay.
My lord, the original owner of the suit land is, my lord, that is at paragraph 1, my lord, page 44. My lord.
Hmm.
The name, my lord, paragraph 2, my lord,
Yes.
that Premsukh Agarwala, son of late Bansidhar Agarwala, number 2, Dulichand Agarwala, son of late Ram Gopal Agarwala, were the original owners of the land.
Hmm.
So the original owners were Premsukh Agarwala and my lord Dulichand Agarwala.
Yes.
Then my lord may come to paragraph 4, my lord.
Hmm.
Paragraph 4, my lord.
Hmm.
That the defendants are relations, that the Jogen Singh, the defendant number 1, since deceased is the husband of the sister of the defendant number 2 and 3, who are own brothers. The defendant number 1 came into occupation of the suit premises described in the schedule.
No, no, we're not understood. Defendants are relations of the plaintiffs,
The defendants are relatives, my lord. It's
of the
not-
plaintiffs,
No, my lord, there are 4 defendants.
or they are related to each
They
other.
are related to each other,
Okay.
dependents.
Okay.
That the Jogen Singh, the defendant number 1, since deceased, is the husband of the sister of defendant number 2 and 3, who are own brothers. The defendant number 1 came into occupation of the
2 and 3 are brothers, and their sister is married by the defendant number 1.
1. The defendant number 1 came into occupation of the suit premises described in the schedule below as a tenant according to English calendar month under the original owners Sri Premsukh Agarwala and Sri Dulichand Agarwala upon terms and conditions among others.
Okay. Thereafter?
Then, my lord, the terms and conditions are given here, my lord, at page 46.
Hmm.
This is the, as per the plaintiff, the tenancy terms and conditions. Then, my lord,
What is the name of the plaintiff?
plaintiff, my lord, there are 3 plaintiffs, my lord, Sogra Khatun, Asma Khatun, Jamila Khatun.
They claim to have purchased from this
This, my lord,
Agarwala.
Agarwala, my lord,
Oh.
Premsukh,
And at that time, they, as per their version, the defendant number 1 was already an existing tenant
Yes.
of the earlier owners.
earlier owner.
Okay.
But the date of tenancy or when the tenancy started, nothing is stated in the plaintiff.
Okay. Did you recognize them to be the landlord later on?
No, I did not recognize, my lord. I am recognizing the original 2 owners, my lord, Dulichand Agarwala.
Okay.
My stand in the written statement is after coming into possession of the land. After 4-5 years, we come to know that
There's no atonement of
no,
from your side.
no.
Okay.
Then, my lord, after terms and conditions, my lord, that the Jogen Singh
Hmm.
inducted the defendant number 2 and 3 in the premises. The original defendant number 1, since deceased himself carried on the business of the absence upon the eastern room of the ground floor and resided with family in the eastern room of the first floor of the 2-story house and the eastern house attached to the 2-story house. The defendant number 2 and 3 carried on the business. Then, my lord, all the descriptions are there, my lord. Then paragraph 5, my lord, page 47.
5-7.
47, paragraph 5.
Okay.
Next.
Just a minute, please. Yes.
Paragraph 5, that after the death of Dulichand Agarwala, the original defendant number 1, since deceased, duly atoned to the joint owners, the said Premsukh Agarwala, Anantram Agarwala, and Vijay Kumar Agarwala as his landlord and paid rents to them.
There is a statement of atonement.
Yes, this is by the plaintiff. He, however, with the passage of time, became irregular in payment of rent and defaulted to pay rent since about last 5 years. Well, this suit was filed in the year 86.
Yes.
The suit was filed in 86. They purchased in the year 1984. And my lord, in the plain they stated that from the last 5 years, this defendant failed to pay the rent.
Yes.
Then para 6, my lord, that the state vendors as well as the plaintiffs duly informed the original defendant number 1 of the plaintiff having purchased the said premises and become the owners of the same. The original defendant number 1 did not atone to the plaintiff nor pay any rent to them in respect of the said premises. The defendant number 1 instead, along with some living similarly in other premises in the land purchased by the plaintiff, raised objections to the revenue authorities and filed mutation appeal case number 8 of 1984-85 before the additional deputy commissioner Dibrugarh, district Dibrugarh, against the mutation of the plaintiffs in respect of the land. They also on 29/5/85 raised objection to the municipal authorities against the plaintiff's application for mutation of their names in respect of a standing house under the aforesaid municipal holdings. That the original defendant number 1 has therefore no right to occupy the suit premises. His occupation of the same is unauthorized and wrongful.
Okay. Yes.
The original defendant number 1, in spite of the above, sometime in 1982, steps to make some unauthorized construction to the premises. This was objected to municipal authority by Anantaram Agarwala, attorney of Premsukh Agarwala. This further aggravated his above misconducts. The defendant number 2 and 3 were inducted in a part of the premises by the original defendant number 1, and their occupation thereof is still more unauthorized. The plaintiffs also bona fide requires the premises for their own use and occupation, that the plaintiffs above conduct have cast cloud to the plaintiff's right, title, interest in these suit premises. Then, my lord, all these are there. Then prayer is at page 49.
Patti?
49.
Yes.
There. My lord, number 1 is declaration of the plaintiff's right, title, and interest in the suit premises described in the schedule below, and cast possession thereof by ejecting the defendants and their dependents therefrom. Rupees 546 for compensation to use and occupation of the same.
Okay.
Then, my lord, all the defendants have filed their written statement jointly. That written statement is at page 51.
5-1.
51.
Yes.
Here I am relying on paragraph 5, madam, with regard to the repeating ownership of my original paragraph 5. May I
Hmm.
read?
Yes.
That the statements made in para 2 of the plain to the effect that Premsukh Agarwala and Dulichand Agarwala were the original owners of the land measuring 2 katha 2 lesa of dag number so and so, periodic katha number so and so, Hijogiri Tinsukia town are admitted.
Yes.
So I am admitting the two owners.
Hmm.
Then, my lord, the story of the defendant, lordship will find at page 54.
Hmm.
Page 54, paragraph 10. What is the case of the defendant? Test, my lord, tenancy and everything is denied, my lord. Para 10,
Yes.
merit. That the allegations made in para 6 of the plaint are denied. It is specifically denied that the state vendors as well as the plaintiff duly informed the defendant number 1 of the plaintiff having purchased the state premises and become the owner
Okay,
of the
okay, we have an idea, yes. Then,
as the remaining part of the state para is vague, incomplete, and writing its material part. It is submitted that the name of the defendant's big tenant under anybody in respect of the suit premises portion of the atonement by the defendant not arise at all. It is also submitted that since about 30 years back, the defendants and their predecessor in interest came from Aisan village near Dibrugarh after the erosion of their lands and occupied the land on which the suit premises stand and raised their own constructions, and since then they have living thereon, doing all acts of possession openly to the knowledge of all, including the then recorded owners of the land, adversely to their interests. Other occupants on the land alleged to be purchased by the plaintiff to occupy the same from before the defendants, their predecessors in interest. Without prejudice to above, it is also submitted that some years back, the then owners of the land occupied by the defendants and others also entered into an agreement to sell this state land to the occupiers at a consideration of so and so. So this is basically their case matter. About 30 years back, they come into possession of the suit land.
okay,
But the judgment of the trial court is at page 26.
by which the suit was dismissed.
Yes. Trial.
26.
Yes, I did start from page 26.
Date,
29/4/2000.
yes,
Well, issues are at page 28.
page,
28. Yes.
yes,
Here, my lord, issue number 2 and 6 are relevant, my lord. Number 2 is whether the plaintiffs are not the owners of the suit premises.
yes,
And number 6 is, my lord, whether the defendants are tenants under the plaintiff's by operation of law.
hmm. Yes,
My lord, issue number 6, it starts from page 29. And my lord, with regard to whether they are the tenant or not, my lord,
page,
it starts from page 29, my lord.
issue number 6, right?
Whether the defendants are tenant under plaintiff by operation of law, and the finding is at page 31.
Page
31.
31.
Yes.
Yes.
31, my lord. First paragraph, my lord, last 3 lines I'm reading.
Hmm.
Yet as the plaintiff has miserably failed to prove the original tenancy under the seller, hence I come to the conclusion that defendants are not tenants under the plaintiff. Issue number 6 is decided in negative.
Yes.
Then, my lord, issue number 2, it starts from page 31.
Yes.
My lord,
What was the evidence adduced by the plaintiffs
My lord,
towards the issue of tenancy?
towards the issue of tenancy, my lord, they have examined total 3 witnesses, my lord. One is Lal Muhammad, he is the power of attorney holder of plaintiff number 1. He is the husband of plaintiff number 1. Number 2 is Anantram Agarwala. He is the one of the vendors. One of the vendors who has sold the land, my lord. And number 3 is Ashraf Ali. He is the neighbor of the plaintiff.
What does the vendor say?
Vendor says, my lord, that these persons are in possession of the fruit land from the time of his father, my lord. But exact date he has also not said.
Regarding the tenancy with the original owners?
He says, my lord, they are these defendants are the tenant from the time of his father,
Tenants.
tenants. And since 1980, they are not paying any rent. That he has explained
1980.
since 1980,
And suit was instituted when?
86.
86.
86.
84 they purchased the property.
Yes.
You have not filed any counterclaim challenging their title over the land in question on the strength of the sale deeds. Sale deeds are not the subject matter of challenge.
Not that.
You want to
Defend my
relate
title.
your title on the basis of adverse
Adverse
possession
possession.
only. No, see, there may not be any materials that you on your part have made an atonement that they are your present owners, present landlords. Let us assume that there is no act on your part recognizing them to be your landlords. Okay, let us assume. But there is some evidence that you had been the tenants of the original owners. The ownership changed hands in the year 1984. 86 the suit was instituted. So how do you reckon or calculate the requirement of adverse possession?
My lord, with regard to tenancy, my lord, except the statement by the attorney holder as well as the print and the PW2, he is the vendor. There is nothing, my lord. When the tenancy starts, even there is contradiction.
What was your cross-examination to the legal heir of the original owner?
But, he was basically examined with regard to the fact that, my lord, since they follow the Mithakra family, my lord. So the Dulichand Agarwala, who is the original owner of the land, my lord. So our plea is that all the legal heirs of Dulichand Agarwala has not sold the land, therefore the sale deed is not valid.
No,
The cross-examination in this field.
that on that line we may not go further because there was no independent challenge.
That is not.
There was no counterclaim or an independent suit. So that part is not the subject matter before us.
But even followed the
Now, there are only, if it boils down to only a very small issue.
that was
Your claim of adverse possession vis-a-vis their claim that you are tenant of the original owner and by virtue of the sale deed, you have atoned the tenancy and recognized them and you have not paid any rent and therefore the proceeding was initiated by which time you did not complete 12 years. Or even their worst case for the plaintiff that you are not the tenants, but from the date when they had come into the shoes of the original owner by virtue of the sale deed till the time of institution of the suit. He had not completed 12 years.
My lord, my case is that, my lord, about 30 years back,
That we have seen.
yes, my lord, 30 years back, they have come into possession of the suit. So if it is 86, then 30 years, it will be around, my lord, 50.
No, but you had come into possession. You had also said that open to the, you are in open possession, you are adverse to the rights of, you have not used the word adverse, but you have
But open,
sufficiently said, open
Open.
assertion of your rights.
Yes.
You are possessing.
Yes.
You have not said anything about payment of rent.
no, I will,
Is there any material from which the relationship of tenancy and landlord with the original vendor,
nothing. We have denied that we are the tenant,
except the statement of the PW2?
nothing is there. And the defendants have specifically denied that there is any tenancy.
Original defendant number 1, you said, was running a shop, ration shop.
Yes.
In the building. The adverse position normally is assumed or happens in some portions of land, not in one part of a building.
No, my lord, the defendant's case is that, my lord, they occupied the fruit land in the year 1958-59. Thereafter, they have constructed this, my lord. Initially, there was some rooms, and in the year 1982, they have constructed, my lord. This is, although it is a 2-story, but this is a wooden structure, my lord. That's why in 1982, the municipal authority has given one notice to defendant number 3, my lord, by saying that you are building a unauthorized construction, therefore stop the construction, my lord. These notices are on record. This is in 82, the municipality raised objection. So the defendant's case is that, my lord, they occupied the land. Later on, they constructed some rooms, and then, my lord, this 2-story wooden structure.
The notice by the municipality will not bestow any right upon you. Municipality may not be knowing who is the owner or.
No, I'm not only the fact, my lord, how this was objected and how this. So this construction is made by the defendant.
But nonetheless, issue number 6 has been decided against them.
Against them. Both the courts held that these defendants are not the tenants. But the trial court comes to the
Not the tenants of whom?
of the original owners, as well as since original, they are claiming that these defendants are the tenants of the original owners, my lord, this Tulisan and all this, my lord. So they are not the tenants, my lord, at any point of time of anybody.
No, see the finding at page 31.
With regard to issue number 6, my lord.
6, yes, please read. The finding is that hence I come to the conclusion that the defendants are not tenants under the plaintiff.
Yes.
That's a different aspect. Even assuming that you are not the tenants of the plaintiff, but qua the tenants, qua the present plaintiffs, what is your strength? What is the strength of your plea of adverse position?
My lord, with regard to the finding on issue number 6, my lord, the plaintiff's case is also not that they are the tenants after purchasing. They says that, well, that when they purchase the land, these dependents are already the tenants, my lord, of the original owners. This is their case. So although the finding, the wordings are there, but if lordship goes to the entire issue number 6, then that is clear that they do not claim that they after purchase these persons come into being the tenant.
That is the point we are trying to extract something from you. The finding of the court is that there is no materials to come to the conclusion that you had been their tenants. No problem with that. But there is no finding that you were not the tenants of the original vendors also. This finding may not be determinative so far as your claim for adverse possession is concerned. They came into the shoes of the original vendor in 84. Suit was instituted in 86. If you had been tenants of the original vendor. You are tenants till 84. It's a different matter whether you are paying rents or not. That's a different aspect altogether, and whether they had taken any action against you. But there is no determination regarding your tenancy, whether there was any relationship of lender-tenant of you and the original vendor. They claim they have purchased in 84, 86, they have instituted this suit. So if you want a plea of adverse position to be taken into consideration, it has to be 12 years, wherein 12 years they were not even in the scene. 12 years, it would be in the context of the original owners. Original owners, there is no finding whether you are tenants, whether you are permissive possessors, whether you are adverse possessors.
If Lord may come to page 30, man. Please.
30. Yes.
I'm reading from second paragraph. PW2.
Please read.
PW2 Anandram Agarwal in cross replied that as the land belonged to Dulichand and Premchuk, hence the houses standing there and also belong to them. It is never revealed by him that houses were constructed by Premchuk and Dulichand. Hence it appears that he has no personal knowledge about who constructed the house over the suit land. The admission of PW2 in cross that dependents are sitting on the land prior to execution of sale deed implies that they are not tenant regarding the suit premises, as because had they been tenant of suit premises, the PW2 would not have admitted that they are sitting on the disputed land, but would have stated that they are tenant on respect of the houses. He also could not answer when his father installed dependents in the suit premises. Not a single witness who has knowledge regarding construction of the houses by Dulichand and Premchuk and regarding tenancy between dependent Jagan Singh and Dulichand, Premchuk, and later on with Anantaram and Vijay was examined by plaintiff side. Any person from the neighborhood could have been examined in this regard. Not a single document regarding payment of rent to prove tenancy could be shown by plaintiff side. PW2 Anantaram, who is the seller, who admitted showing income from house rent in the income tax return, must have maintained records regarding income from rent, but no such document would be shown by him as a proof of tenancy. Moreover, in the pleading, it is revealed that rent was payable at the end of each month, which is quite contradictory to the evidence of PW2, where he has stated that rent is payable on the first week of each month. From all these above facts and discussions, it appears that plaintiff has miserably failed to prove the fact that defendant Jagan occupied the suit premises as tenant under Dulichand, Premchuk, and later on, after his death, atoned to heirs of Dulichand.
Okay.
The finding is there, my lord, that there is no point of time, my lord. And my lord, my case is that since I'm occupying more than 30 years, so after 12 years, that title extinguished, my lord. So the sale date, whatever they have executed in 84, is not a valid sale date.
The conclusion precedes the discussion wherein the PW2 even could not produce a single document regarding tenancy of the defendants with his predecessors. And he did not even use expressions of tenancy. He said, you are sitting on the land. Let us see his examination. Do you have? Okay, we'll come to the evidence later. You complete your part, then we'll come to the evidence.
This is with regard to, my lord, issue number 6, my lord. Issue number 2, my lord, that is irrelevant. My lord, issue number 2 is with regard to, my lord, ownership and adverse possession, my lord.
Page,
my lord, it starts from page 31, my lord.
hmm,
I'm not reading the entire, my lord, it
Yes.
is a long discussion. My lord, I'm reading from page 34, my lord. It starts from page 30.
at 30,
It starts from page 31,
that means we are
and
reading
I'm reading from page 34, my lord.
3, 4,
34.
yes.
But, I'm reading from the starting, my lord, because
Yes.
in between there are some lines.
Yes, please.
Cannot be treated as the notice issued by the state leader as per plaintiff's instruction, and this does not in any way help the defendant's case. But already it is discussed earlier that defendant has been able to prove the fact that they, along with their predecessor, come to the land where suit premises situated in the year 1958-59, and their father constructed a kacha house there in the year 1958-59, and thereafter some houses were constructed in 1 katta 2 lesa of land. It is also proved that their father installed a tea hotel also there, and later on in 1982-83, the original 2-room house was converted to 2-story asbestos-proof building. Already it is discussed that plaintiff has miserably failed to prove tenancy relationship between Dulishan on his heirs and dependent Jagan. They also failed to prove that houses were constructed by Dulishan. How can then the heirs of Dulishan transfer the house of holding so-and-so to plaintiff, which was not constructed by Dulishan? Dulishan dies in the year 1967. Hence, admitted fact is that from many years prior to 1967, defendants are in possession of the suit premises. It is proved by defendants that they are occupying suit land since 1958-59 by constructing house. Defendants pleaded that as they are in occupation of the suit land by constructing house thereon, denying the title of the true owner and without any interruption, hence title of the original owner extinguished. It is well settled law that mere possession, however long, does not necessarily means that it is adverse to the true owner. An adverse possession means a hostile possession which is expressed or implied is denial of the title of the true owner. The principle of adverse possession is a distinct concept which analyzes that the possessor is possessing the land openly and thereby assert hostile title against the real owner by making certain overtly acts. The citation placed before me by the plaintiff side so-and-so speaks that mere continuation of unauthorized possession for more than 12 years does not mean adverse possession, and regarding adverse possession, there must be some overt act on the part of the person claiming adverse possession, indicating ascertainment of hostile title, and the indication must be to the knowledge of the owner. One of the requisites of adverse possession is that it must be open and notorious. The word open and notorious possession as applied to the adverse holding of land by another mean that dispossessor claim of ownership must be evidenced by such acts and conduct as are sufficient to put a man of ordinary prudence on notice of the fact that the land in question is held by the claimant as his own. In the present case, the defendants and predecessors are occupying the land measuring 1 katta 2 lesa of dag number so-and-so, patta number so-and-so by clearing the jungle and constructing house thereon. Moreover, tea hotel was also opened there. All these acts of possession and construction of house, opening of tea hotel, giving house on rent to tenants shows that the land was occupied by the defendants and his predecessor as their own openly, continuously since 1958, hostile to the title of true owner. Without any interruption from the original owner, the land is occupied and houses were constructed. Hence, after 12 years, that is after 1970, the original owner's title over the suit premises has been extinguished, and by law of adverse possession by occupying the land adversely to the interest of the true owner, for a period of 12 years, the defendants acquired the title of the suit premises. The right title of the original owner being extinguished over 1 katta 2 lesa of land, and the houses not being constructed by Dulishan, and the heir of Dulishan has no right to transfer the said land and houses occupied by tenants. The original owner's title being extinguished since 1970 by adverse possession of defendants and their predecessor for more than 12 years. The fact admitted by DW3 that about 10-12 years ago, that is about 1980-82, some transaction of payment of 10,000 occurred between here and Anantaram. And in pursuance of the said transaction, rupees 800 was given to Anantaram does not in any way hamper the title acquired by dependents by law of adverse possession. For argument's sake, even if it is held that theory of adverse possession fails, yet the sale deed not being executed by all the heirs of Sulishan, who had repeatedly followed Mitaksara school, the sale deed executed to does not confer any title to the plaintiff regarding suit premises. Accordingly, issue number 2 is decided.
This part we may not concur with.
We are not going into this, but
This part we may not concur with. Sale deed was not the subject matter of challenge.
not self.
So
With
there is no
regard to-
occasion to go into that aspect.
We
Whether
only with regard to adverse possession. The finding with regard to adverse. This is the finding, my lord, and on that basis, my lord, the trial court has basically dismissed the suit, my lord. Against that, my lord, the plaintiff preferred appeal, my lord.
yes,
My lord, the appellate judgment is at page 5, my lord.
appellate
Appellate judgment is at page 5, my lord.
5.
5.
Yes,
The judgment dated 14/7/2008. Passed in title appeal number 11 of 03.
yes,
My lord, before the appellate court, basically the finding of issue number 2 and 6 is challenged by the plaintiff, my lord.
yes.
And that this issue starts from page 9, my lord. Decision on issue number 2 and
Page?
page 9.
Mm. Yes,
So they have decision on issue number 2 and 6, my lord, and then my lord, page 11, the evidences are discussed here. Page 11.
yes,
But I'm reading from paragraph 16, my lord. Here the evidences are discussed. What are the evidences adduced, my lord?
yes,
The plaintiff pleaded that defendant Jagan Singh was tenant under original owner Dulichand Agarwala and Premsukh Agarwala of the suit premises. After death of Dulichand Agarwala, the suit premises was inherited by legal heirs of Dulichand Agarwala, that is the son of Anantaram Agarwala and Vijay Kumar Agarwala along with Premsukh Agarwala. It is found from the evidence on record that Premsukh Agarwala along with Anantaram Agarwala and Vijay Kumar Agarwala on 2184 by registered sale deed number so and so, sub-registrar office Tinsukia,
yes, we have read.
so sold the suit premises with standing houses therein to the plaintiff for valuable consideration and possession also delivered to the plaintiff. The state sale deed is exhibit 2. On perusal of this state sale deed, it is found that the above three executant by exhibit 2 sold the suit premises of 2 Katha 2 Lesa land on 2184 to plaintiff Sogra Khatun, Asma Khatun and Jamila Khatun of Tinsukia town. In the page number 5 of sale deed, exhibit 2, it is also mentioned that the owners of the suit premises sold together with all buildings, trees, fences, etc. In this connection, plaintiff examined one of the vendors, Sri Anantaram Agarwala, as PW2. PW2 Anantaram Agarwala, in his evidence, specifically admitted about the execution of sale deed, exhibit 2, by Premsukh, Anantaram and Vijay Kumar Agarwala. In the evidence, PW2 mentioned that the defendants were tenants under them
at the rate of rupees 200 per month of English calendar at the end of each month, the dependents failed to pay rent from 1982 to the owners of the suit land. Further, dependent number 2 and 3 entered into the suit premises under dependent number 1 without obtaining any permission to the owner of the suit land. PW2 also stated that the holding number of the suit premises is 3369 given by municipality. PW2 in further evidence stated that before selling the suit premises, permission obtained from Development Authority by Exhibit 6. On perusal of Exhibit 6, it is found that permission was given by Tinsukia Development Authority by Exhibit 6 to sell the suit premises, 2 Katha 2 Lesa land of suit patta to plaintiff. After purchasing the suit land, plaintiff applied for mutation and by order dated 9/4/84 of Miss case number so got mutated their name in the revenue record of suit premises. PW2 in the cross-examination also specifically stated about the execution of this sale deed. Exhibit 2 by executant. Exhibit 5 is the periodic patta issued by Revenue Authority for so-and-so land in the name of original owner Duli Chand Agarwala and Premsukh Agarwal. The mutation of plaintiff was objected by defendant by challenging an appeal before the Revenue Authority. Defendant number 1 did not atone under the plaintiff that they were tenant. Defendant specifically denied about the tenancy and claimed the house over the suit premises constructed by them and their predecessor in interest. According to defendant, the predecessor in interest of defendant have been occupying the suit since about 30 years back. And they have also denied that they were tenant under Duli Chand and Premsukh Agarwala. PW1 in his cross-examination in chief stated that all defendants were tenant under Premsukh and Duli Chand Agarwal. Well, this is important because Duli Chand died in 1967. The suit premises is their purchased property. PW1 in his evidence specifically stated about tag number, patta number, and holding number over the suit premises. He also supported the plaint that defendant come to the suit premises as a tenant under Duli Chand and Premsukh Agarwala. He further stated that there is a two-story building about so-and-so made up of wood and plank. There is also other side measuring about 6 feet into 6 feet. The defendant number 2 and 3 were allowed to sublet their suit house and they have been also carrying business there.
Duli Chand died when?
1967.
Yes.
The main plea of respondent defendant is that none of the defendants were tenant under anybody in respect of the suit premises, for which question of atonement by defendant does not arise at all. The defendants and their purchasers came to the suit land about 30 years back from Aithan village near Dibrugarh after erosion of their land and occupied suit premises by constructing houses therein. According to defendant DW1, Gautam Chauhan, accordingly defendant number 1, Gautam Chauhan stated that they have been in the suit premises since 1959 after their land eroded by river at Dibrugarh. At first, they started living in different houses and subsequently settled in the suit land by clearing jungle and constructing house with 2 rooms over 2 Katha 2 Lesa land. But in cross, he stated that although they have been residing in the suit land since 1959, no attempt was made by them to enter their name in the revenue record of the circle office. No notice received by them from any person or municipality office. Premsukh and legal heirs of Duli Chand have no right to sell this land to plaintiffs. In further cross, he stated that he come to know about after 4-5 years remaining over suit land that suit land belongs Premsukh and Duli Chand Agarwala. DW2 Saraswati Devi has also supported the evidence of DW1 by possession of suit land by dependents from 34-35 years by constructing houses after clearing jungle. DW3 Nandan Chauhan has also stated about possession of suit land by dependent since 1959. This witness has also supported the evidence of DW1 and DW2. DW2 in his evidence also stated that the holdings were constructed about 13-14 years back. He failed to say who was the owner of the suit premises in cross. He has not paid any municipality tax, land revenue of the suit premises to the authority.
the burden lies on the plaintiff that they acquire title over the suit premises by way of purchase. Then, my lord, all these are discussions are there. Then lordship may directly come to page 16. The finding is there. Evidences are discussed there, my lord. Page 16.
Yes.
From paragraph 28 onwards. Paragraph 28.
Hmm.
Law is well settled that in order to claim adverse possession, defendant must show as to from which date he denies the title of plaintiff and starts possession of the land adversely to the knowledge of true owner of the plaintiff.
Hmm.
In the present case, DW1 specifically admitted that he came to know after 4 or 5 years remaining over the suit land belonging to owner Prem Sukh and Dulesh Chand Agarwala.
Hmm.
As found from the evidence on record, the plaintiff's title is already proved. But this part, my submission is perverse, my lord, because the plaintiff's title is not proved, my lord.
Why? Sale deed was proved.
My lord, my submission is that the defendant's case is that, my lord, since after 12 years, when they come into the possession of the suit land, my lord, the title of the original owner, that Dulesh Chand and their extinguished, my lord. So whatever the sale deed is there, my lord, that is not valid because their title is extinguished. So if they do not have the title, then they cannot transfer the title.
No, but the transaction made by the original vendors with the plaintiff, that is not one of the issues.
No, that is not not one.
That is not it's a different aspect that whether your claim for adverse possession would defeat their their title. That's a different claim.
The defendant is to prove his title that he acquired by way of adverse possession. The defendants, although possessing the suit property, never approached before the revenue authority to record their names in the revenue record in view of long possession. Defendants never made any hostile declaration against the plaintiff or original owner at any point of time to show it from the date when the plaintiff had instituted the suit. A person pleading adverse possession, no equities in his favor, since he is trying to defeat the right of true owners. The court below failed to apply its mind as to the principle laid down in various judgments to accept the title claim on basis of adverse possession. In the present case, it is also found that there is no counterclaim from the defendant's side, except the self-contradictory amendment placed in the written statement as stated above. There is no item of pleading and evidence to show that the defendants acquired title over the suit premises by way of adverse possession. It is categorically held in various decisions that mere possession will not be sufficient to constitute.
This discussion, is it in accordance with law? Is it Chaudhary? Adverse possession is a defense.
Yes.
It's a shield, not a sword. He is not supposed to go to the office to get his name registered. When there is an action against him, he takes this as defense. This discussion perhaps is a lack of proper understanding.
Because the evidence
You
also,
don't claim adverse possession in go in an office.
no, because in the evidence on the written statement, there is no specific requirement regard to the fact when it becomes adverse. So
59 he has said,
Which-
59 he has entered possession.
that part is there, but that was with regard to a tenants, because that aspect of the matter has been proved by the PW2 that these persons were a tenant.
Now that has been, see, the question of tenancy with you, it's a separate matter altogether. Question of tenancy with the owner, you may have some point to harp upon. The only evidence is PW2. PW2 did not produce a single rent document.
But in the cross-examination also, he has established this aspect of the matter. So the
If
questions
he
were
was
put-
receiving rent, it was not reflected in his books of account. But since this is not a landlord tenant, we may not go to that extent, whether it was reflected. But we would definitely look into some substantial evidence to come to a finding or to record any finding on the correctness of the finding of the first appellate court
First.
that they were indeed tenants continuing since 1959 till the land was transferred to you.
because the notices were exhibited by the plaintiff. These notices are there because in the current war appellate two,
Notices for?
notices with regard to the fact that we have become the landlord of this particular land. We have subsequently purchased the notices were duly issued to the
And,
defendant.
have you seen your, the relief which you had prayed for in the plaintiff? There is no relief for any rent,
No, this is basically for ejectment of the,
ejectment of what?
doesn't mention the
Ejectment
tenant.
of whom?
Yes,
Of a
doesn't-
tenant
It
or
has-
an unauthorized occupier?
has been mentioned like
Once
that
you say unauthorized occupier,
Yes.
then we have to examine the aspect of adverse
because
possession.
the
If you had said that he's a tenant not paying, what 12 years, 20 years, 30 years, but permissive possessor not paying rent?
because lordship here in this case, the defendant has not,
See your prayer, we have just noted somewhere. The plaint, it starts at page 42. You come to the relief which you have prayed for at page 49 perhaps. Yes, 49. See declaration, have you got 49?
yes, lordship, the difficulty is that I have not supplied with a copy of this second appeal. All the documents are not there, reading from my own.
It is your own plaint.
Yes, I'm from
Doesn't
reading
matter.
from my own.
Declaration that the plaintiff's right, title, and interest in the suit premises
Yes.
described below and cast possession thereof by ejecting
Eject.
and the defendants. So and so for compensation of use of an occupation of the same.
Compensation otherwise because there was no issue with regard to that. But the ejectment part is there,
You
lordship.
not only you have omitted to ask for any area rents, on the other hand, you said, I need compensation for use.
Compensation part is there, but there is no issue with regard to
And
that.
see
lordship.
number 3, cost.
Yes.
So the question of they being your tenants is totally out of context.
Yes.
It will not be a part of the discussion. So what remains is whether they were tenants of your vendors,
Yes.
number one,
The original.
original vendors, and whether such tenancy could have been proved in accordance with law. Then he will not be able to take the shield of a adverse possessor. Now, the evidence is of PW2
PW2.
because you do not know.
Because PW2
You
in the
know
cross
whatever
examination.
you have deposed, it's only hearsay. That I have been told, it is only the PW2 who will have first-hand knowledge. And one of the original vendors under whom they are supposed to be tenants, he passed away in 1967.
Yes.
That Duli Chand.
But that explanation is there in the cross plot. I did the cross. The cross, he has made a mention in vernacular. In
What has
cross-
been stated?
Yes, the cross examination, he has made a mention, lordship.
Okay, anything else? Or you complete, then we'll come to Mr. Chaudhary.
That is not submission, my lord.
Any case laws?
Yes, so but there is one that is not required, my lord. If
Why
lord
not
goes-
required?
Yes, my lord, because the
Why not required?
Let the finding of the learned first.
If we have given you enough cue on the discussion of the first appellate court that you did not go before the office to claim your right, those are not required to take the defense of adverse position. There are many case laws. You should have-
But with regard to the finding of the learned first appellate court, my lord, Lord has seen what are the things that are taken for consideration.
Yes. Yes, then Mr. Chaudhary, yes. Yes.
The lower appellate court, they decided these two issues with regard to the whether the owners of the suit premises and whether the defendants are tenant under the plaintiff by operation of law. These 2 and 6, these two issues are taken together, and accordingly the finding was there with regard to that. Lordship, kindly see the paragraph number 18.
Of the first appellate court judgment,
First appellate court,
paragraph 18,
18.
internal page 8.
page number, internal page 8.
Eighteen.
18, Lord.
Yes, please read.
The mutation of plaintiff was objected by defendants by challenging an appeal before the revenue authority. Defendant number 1 did not atone under the plaintiff that they were tenant. Defendants specifically denied about the tenancy and claimed the house over the suit premises constructed by them and their predecessor in interest. According to defendant, the predecessor interest of defendant have been occupying the suit land since about 30 years back, and they also denied that they were tenant under Dulichand and Premchand Agarwal. PW1 in his examination in chief stated that all defendants were tenant under Premchand and Dulichand Agarwal. The suit premises is their purchased property. PW1 in his evidence specifically stated about tag number, pattern number, and holding number over the suit premises. He also supported the claim that defendant came to the suit premises as a
Who is
tenant.
PW1?
The PW1 is the plaintiff.
He is the purchaser.
Yes, but is
Plaintiff, his evidence is only hearsay.
yes, sir.
PW1 is power of attorney.
The holding number over the suit premises.
Those can be matters of records.
Yes,
Holding number and
holding
but
number.
in absence of any documents that the present defendants were the tenants of your original owner, vendor, it has to be based on some documents. Unless somebody from the family of the original owner or the original owner comes and deposes that he was our tenant. His evidence, PW1's evidence should not be very relevant. The
Yes.
only evidence you have to rely upon is PW2.
PW2. Now the PW2 with regard to
PW1 is who is PW1? At power of attorney.
Yes, Malad. Say Lal Muhammad,
PW1,
Power of attorney of?
yes,
a power of attorney of
Lal Muhammad.
plaintiff number 1. He is the husband of plaintiff number 1.
Plaintiff one. Plaintiff one did not reduce evidence.
No,
It is only the power of attorney.
Power
Power
of
of attorney.
Even that you know. The law. How much evidence can a power of attorney reduce in a civil proceeding?
because certain documents are exhibited, Lord.
His ambit is only to reduce evidence so far as it is within the ambit of within the four corners of the instrument, nothing beyond that.
Exactly, with regard to that, Lord. Because certain documents are exhibited.
No, was the instrument not the power of attorney, the sale deed? Sale deed,
Yes, Lord.
was it executed by the power of attorney or the PW1? Or the plaintiff number 1?
Sale deed. With regard to sale deed, Lordship, the PW2 has made a mention. There is a statement from the side of the PW2. The evidence
No,
of-
let us reframe the question.
Yes.
Whether PW1, who is the power of attorney of
Yes.
plaintiff number 1, did he have an overt role in the sale deed? We don't think so. Sale deed was in favor of the plaintiff,
plaintiff.
not in favor of the power of attorney, obviously not. And it's not an agreement, it's a deed of sale. Yes, please proceed, Mr. Chaudhary.
Yes, Lord. Now, if we are not taking into account the evidence of PW1, the attorney holder, now
Yes.
the Planet God Appellate Code in paragraph 21, Lordship,
2-1.
21, in internal page 9, Lordship, this
Yes.
the PW1 and the PW2 was taken into account. According to defendant,
Just a minute, please. Paragraph 21 you are reading?
yes, sir.
Yes, please. Please read.
Accordingly, defendant W1, Gautam Chauhan stated that They have been in the suit premises since 1959 after their land eroded by river at Dibrugarh. At first, they started living in different houses and subsequently settled in the suit land by clearing jungle and constructing houses with 2 rooms over 2 kata 2 acres land. But in cross, he stated that although they have been residing in the suit land since 1959, no attempt was made by them to enter their name in the revenue
So
record
this part we have a
Yes.
problem.
of circle office. No notice received by them from any personal municipality office. Premchuk and legal heirs of Dulichand have no right to sell the suit land to plaintiff. In further cross stated, came to know after 4-5 years debating over suit land that suit land belonged to Premchuk and Dulichand. So he has made a statement with regard to 4-5 years remaining over suit land. That suit land belongs to Premchuk and Dulichand Agarwal. Now the DW2 lordship. DW2 with regard to the possession of the land by the DW1.
Hmm.
With regard to the fact that evidence of DW1 by possessing of the suit land by defendant from 34-35 years by constructing houses after clearing jungle. DW3 Nandan Chauhan has also stated about possession of suit land by defendant since 1999. These witnesses also supported the evidence of DW1, DW2, DW2 in his evidence also stated that the holding were constructed about 13-14 years back. He failed to say who was the owner of the suit premises in cross. He has not paid any municipal tax land revenue of the suit premises to the authority. Now the burden lies on the plaintiff that they acquire title over the suit premises by way of purchase. From the above evidence, it is clear that Premchuk and Dulichand Agarwal was original owner of the suit premises, which is found from Exhibit 5. Periodic patta number 32, where tag number such and such issued the periodic patta for 15 years. The state patta remained unchanged. Generally, the patta is issued by settlement officer on the time of preparation of patta. Court verification is made from Exhibit 5. It is clear that the original owner of the suit land, Dulichand and Premchand Agarwal, and after death of Dulichand, his legal heirs, along with Premchuk, sold the suit property to plaintiffs. It is found from the evidence at the time of selling. Necessary permission granted to vendor by development authority in Chukia. Further, in the sale deed Exhibit 2, it is clearly mentioned about the house over the suit premises. This fact is supported by Exhibit 9 and Exhibit 9.6. Municipality tax payment received which in the name of plaintiff for holding number such and such ward number 15. Exhibit L, municipality assessment
Mr.
report.
Chaudhary,
Yes,
to defeat the defense of adverse position, this
Yes.
may not be relevant. You may have all the document,
but there was no counterclaim with regard to that.
not required,
Because
not required.
otherwise,
It's a defense.
yes, the defense regard the claim made by the
It's not a
defendant.
perfect title they require by adverse position.
Yes.
It only defeats the title of the, and this is a right recognized in spite of the equitable jurisdiction.
Yes, equitable jurisdiction, but
It overrides equity. Otherwise,
because
it will
the
be-
learned law.
otherwise, if
Yes.
you normally see, it would be very kind of audacity that a person having everything, his title is lost only because, but that is the law.
No, but the thing is that lordship is how
I
it-
may have all the papers, all documents, I may be paying revenue regularly, but somebody is in possession of my land in hostile assertion of his rights. I am doing nothing. 12 years passes. I cannot claim the
no, the issue is that lordship, it becomes hostile. We take note of that. That the rent was not paid. The rent was the admitted position, it was not paid since 1980. And the suit was filed in the year 1986. So this point of adverse position.
No,
would not come in that way, Lord.
where do you get? That was what we are trying to extract.
Yes, lordship. In the,
That rent was indeed paid.
yes, lordship. In the evidence of the PW2, he has made a specific statement in the cross-examination also.
Let us see that.
Yes. I'm just reading that in vernacular lordship. মই 1980 চনলৈ ভাড়া পাইছো আৰু তাৰ পিছত ভাড়া পোৱা নাই. So it is the matter
Bhara paisa from whom?
from the defendant. It has been mentioned here. বিবাদীগণে মোৰ দেউতা আৰু প্ৰেমচুক আগৰৱালা কি বহাইছিল, কোন চনত বহাইছিল নাজানো, বহুত বছৰ ধৰি ভাড়াটিয়া আছিল। মই 1980 চনলৈ ভাড়া পাইছো, তাৰ পিছত ভাড়া পোৱা নাই। ভাড়া নিদিয়াৰ বাবে মই কোনো নোটিছ দিয়া নাই। So it is been specifically mentioned in the cross. We take into account
In the cross.
in the cross. It is there in the cross. Because the evidence part when this question was put to him in the cross examination, he made a statement that
In the chief, did he say that?
yes, in the chief also it has been mentioned. I'm just reading it.
Who is PW two?
PW two lordship is the
Anantram Agarwal.
Anantram Agarwal. Is the son of Bichand Agarwal.
He says that till 1980 he had received
Yes.
rent.
Rent.
What was the next question put to him? What was the next answer? What is the next
Yes.
answer? Next
Yes.
line.
Yes.
He must have definitely
Yes.
made a similar statement in the chief examination.
ভাড়া নিদিয়াৰ বাবে মই কোনো নোটিশ দিয়া নাই
Hmm.
বিবাদী উত্তৰ কি নাজানো আগে পাছে কোন আছে জানো বছৰীয়া মাটিৰ ডেছক্ৰিপশ্যন অফ দ্য লেণ্ড যোৱা 5-7 বছৰ মাটিত সোমোৱা নাই সত্য নহয় যে আমাৰ দুজনৰ আগে এই মাটি বিক্ৰী কৰাৰ কোনো অধিকাৰ নাই সত্য নহয় যে বিবাদীগণে আমাৰ পৰা কোনো ঘৰ ভাড়া লৈ থকা নাছিল মই ইনকাম টেক্স দিওঁ
Hmm.
কিমান মই ক'ব ভাড়াৰ বিষয়ে মই ইনকাম টেক্স ৰিটাৰ্ণত উল্লেখ কৰিছিলোঁ বিবাদীৰ বাবে মোৰ অন্য ভাড়াঘৰ আছে তিনিচুকীয়া নগৰতে আছে মোৰ দেউতাই ইনকাম টেক্সত মাটিত দেখুৱাই ইনকাম টেক্স এছেছমেণ্ট কৰিছিলে নেকি নাজানো সত্য নহয় যে প্ৰেমচুক আগৰৱালা দুজনী কি নাছিল আৰু ৱাৰিছ আছিল সত্য নহয় যে বিবাদী মাটিৰ ঘৰৰ মালিক আমি নহওঁ these are all suggestions.
But he says that in the income tax he used to.
Exactly, lordship. And in 1980 up to 19, this is vital lordship because up to 1980, because he was paying rent up to 1980, this defendant. Subsequent to that, there was no payment of rent. There was no notice issue. And the learned Lord Appellate Court if I read lordship this internal page 13, the paragraph number 31. Paragraph number 31 lordship, the middle portion PW
Page of.
internal page 13 lordship, paragraph 31 of the appellate court judgment. Lord Appellate.
Yes.
So far as issue number 6 is concerned, from the evidence as discussed above, it is found that the plaintiff, although claimed the defendant came to the suit premises as tenant under the ownership of Dutee Chand and Premchuk Agarwala, except the holding number, the plaintiff failed to prove any documentary or evidence in respect to the tenants. PW2 in his evidence specifically stated that defendants have not paying any rent since 1980 after the death of Dutee Chand Agarwal. The present plaintiff, although purchased the suit and under such circumstances, it can be easily presumed about not attorneying the tenancy by the defendants under plaintiff. The exhibit number O and O, registered notice issued to defendants by the plaintiff, are the vital documents about informing wrongful occupation by. So that notice was duly issued to the defendants. Learned counsel responding in his argument has submitted that defendants are not the tenant under the subsequent purchase. The plaintiff has miserably failed to prove the original tenancy under the venture. Yes, it is not proved the defendants are tenant by operation of law. In the result, it is held that learned court decided the issue. So that exhibited document lordship is the clear indication to the fact that these defendants were duly informed about the fact.
What was issue number 6 exactly?
Issue number 6 lordship with regard to the adverse possession.
Issue number 6 is tenancy.
For the defendants are tenant under the plaintiff by operation of law.
What was decided? What was decided by
Issue
the,
number 6
by
is
the
decided
first court, trial court?
Trial court decided in negative.
No tenancy.
no tenancy.
The appellate court also
With regard to the
decided negative.
plaintiff is concerned because the
Appellate court has also
Yeah.
affirmed that
Affirmed.
finding.
there is no landlord-tenant relationship between the plaintiff and the defendant.
But so therefore, the only issue which would require determination is issue number 2.
2.
Adverse position.
Issue number 2 is whether the plaintiffs are not the owners of the supreme. Because with regard to adverse possession, there is no such specific issue frame.
But it was understood.
Yes. But the issue was not framed, Lord, with regard to that adverse position. Whether the plaintiffs are not the owners of the suit premises. That is the other way around it has been framed.
No, these are settled positions. If you go, if there's any lack of clarity in an issue, we can revert back to
Yes,
the pleadings.
yes.
We find sufficient pleadings. So for that, account will not find fault.
Yes. 15
Yes, it would have been better if a specific issue was framed, but it's not done.
So Planet Trial Court based on the exhibited documents arrived at a finding that the the plaintiff had duly purchased the land. There was no counterclaim with regard to the fact that these deeds were put into challenge by the defendants.
So we need to be it need to be ascertained as to whether at the time of purchase of the property by your client, Mr. Chaudhary.
Yes.
The defendants were the tenants of the earlier vendor.
Yes.
Maybe it's a different matter whether they're timely paying the rent or not. And there, the question of their attorneying you as the landlord also may not be relevant, because it is the issue of adverse possession. And adverse possession would be from the date when they have been possessing the property, land, adverse to the interest of the real owner.
Real. The Tanat lower appellate court lordship is, while coming to a conclusion with regard to the judgment of the defendant, relied on the judgment of Honorable Apex Court. Is at page number 11, lordship, internal page 11, paragraph 23.
Yes.
Three judgments were read at paragraph number 26, lordship, pointed out that there is no counterclaim of the claimant defendants over the suit premises for declaration of title, where the learned trial could travel beyond the pleading and declare title in favor of the respondent by virtue of
Where?
in paragraph 26 of internal page 11.
Yes, yes.
It is also
pointed out.
It is also pointed out that there is no counterclaim of defendants over the suit premises.
No, this may not be correct. You do not make a claim on the basis of adverse position. It's a defense.
Yes. Adverse possession claim is otherwise not there, but the judgment what I am submitting, lordship.
No, it is pointed out.
Yes, it is.
That is your contention.
There is no counterclaim of defendants over the suit premises for declaration of title. Otherwise, it is not required.
Not
Because
required. That is your
yes.
contention.
Travel beyond the pleading and declare title in favor of the respondent by virtue of adverse possession. Now, the judgment which I am just submitting, lordship, this is the 1996 4HC. Successor landlord, pre-existing right title interest in the property got extinguished, and appellant got valid title to the property by operation of section 17 of the Registration Act. Since respondent was continuing as tenant, he was bound by the title unless the suit for his eviction laid by appellant right. So that aspect of the matter.
There is absolutely no problem with this. This is the correct proposition.
Yes.
Provided they recognize your vendors to be their landlord.
Yes.
That is also in dispute. It's not a question of not attorneying you as the landlord. They are not even recognizing your vendors as landlords. They are saying that their lands were eroded. So in 56, they came to Dibrugarh looking for land, ultimately found this land, cleared the jungle, had a two-storied wooden structure, construction. They had a issue, later on it was also converted to some, and they are running their business. It's their version. And at no point of time, any notice was even issued by your vendors for their eviction. No proceeding was initiated.
But the lower appellate court came to a finding, lord. There is no evidence with regard to that aspect. This person's, the defendants, was in possession of the property since 19.
They have reduced evidence.
No, there is no documentary evidence.
Then how can there be a documentary evidence of adverse
Because subsequent,
possession?
that is the reason why the learned
Adverse
lawyer-
possession, can there be a documentary evidence?
No. That
Adverse
aspect-
possession is a
yes.
matter of assertion, who is it? And you can, these, whatever they state, these are all rebuttable, you can rebut them, you can cross-examine them.
And the evidence of the PW2 is also important. Because the PW2 person who has deposed.
Because that part, when they had come into the land, perhaps that there you may not have, you may have a very little scope of arguing, because your PW2 has said that they had come, but they had come as tenant.
Because in paragraph 24, Lordship, and is the paragraph 24, the learned trial court, the Lord Appellate Court has made a mention with regard to discrepancy so far as the contention of this defendant is concerned. Because on the one side, the defendant is mentioning about the original, the names of the original vendors. Subsequent stage is disputing with regard to that. So this,
Let us read this, 24.
yes, Lordship, the defendant although claimed the suit land by of adverse possession, the plea of defendant is found to be self-contradictory without any cogent evidence. In paragraph 5 of the written statement, defendant admitted that Premchuk and Dulichan were original owner of the suit premises, whereas in paragraph 8 of the written statement, it is denied that Premchuk and Dulichan were original owners.
Let us see. 5 and 8. Where is your written statement?
It starts from page 51, madam.
Hmm.
The paragraph 5, Lordship will find at the page 50.
Hmm. That is or admitted.
Madam, paragraph 8 is at page 53. Paragraph 8, madam, this third subparagraph.
Or not. Hmm. Of the suit premises,
Yes, sir.
it's not the land. Did you exhibit your sale deeds?
The PW1,
Power of attorney.
yes. Attorney holder. Exhibited this power of attorney, exhibit 1. And yeah. And exhibit number 2 is the deed of sale. Exhibit number 2 is the deed of sale.
Exhibit 2.
Exhibit 2.
Yes, anything else?
The only point is that the defendant, while asserting with regard to the point of adverse possession, nowhere in the written statement, in the evidence also, they have not made a mention with regard to the fact how it becomes adverse.
They have
And-
said,
Yes,
they have said.
there is no specific.
No, no,
adverse-
there is a specific statement. We have noted.
Because the denial part
Come
is
to
there.
paragraph 10. We have noted that. Paragraph 10, the second part of the, we were concerned with that, whether it's there.
Paragraph 10 of the written.
Yeah, written statement, towards the middle, there's a gap. It is also submitted that that since about 30 years back, the defendants and the predecessors in the came from so-and-so village near Dibrugarh after erosion of their lands and occupied the land on which the supervisors stand and raised their own constructions, and since then they are living thereon, doing all acts of possession openly to the knowledge of all, including the then recorded owners of the land, adverse to their interest. It's there. We have noted this.
But the other aspect of the matter is that with the PW2 in his evidence, although this tenancy agreement has not been exhibited, the fact is that it has been specifically mentioned in the evidence or in the cross examination that these persons were a
The
tenant.
tenancy agreement may not even be there.
Yes.
In all cases, we may not insist because there may be an oral agreement, but when there is a litigation, we look for something more, that it should be beyond, in all probability, the fact of tenancy, if it is a disputed proposition by the other side, there should be sufficient materials before the court to come to a finding that there was indeed a tenancy. Mere refusal may not bring to a conclusion. Mere refusal will be a denial. So the question of proving will heavily lie upon you that there was indeed a tenancy. He has said that there was a tenancy. He says about one Duli Chand who passed away a long time back, 1967. He himself was not collecting rent.
Himself was not collected.
His IT returns, he said rents were reflected, but he doesn't know whether these rents were also there. Maybe that was a condition of the sale. We'll sell you. It's your burden, how you evict them. We were not able in our lifetime. And Mr. Gupta is obstinate that he will remain in this land.
My lord, notice my lord issued by them exhibit and but I remember my lord, they have not described me as a tenant. Something unauthorized occupant of some part there. Notice. They have issued the notice to vacate the land. Exhibit and may
You can have a look at that, sir.
Lastly, my last submission with regard to issue number 8 and 9. It is at paragraph number 36 of the
Just a minute, please.
Yes. page 16. Because by exhibiting that particular exhibit 2, plaintiff,
Just a minute, Mr. Arun. Yes, which?
I'm submitting that this exhibit 2 is the sale deed. Exhibiting that particular sale deed, the plaintiffs have been able to establish their the rightful ownership over the land. Now, with regard to other aspect of the matter, its adverse position, but you kindly see the paragraph number 36 of the lower appellate court judgment in page number 16.
36.
36. By discussing the issue with regard to
36 or 20?
36, the last page. Yes. the last
Okay.
part. issue number 8 and
8
9.
and 9,
8 and 9. May I read out?
please.
Both issues have been taken together for decision. Learned counsel for the appellant in the argument referred 2006 1 JLT such and such and argued that under Order 7, Rule 7 of CPC submitted that when any other relief is not sought in the plain by the plaintiff, the court can grant appropriate relief to the party when court finds sufficient materials on the record.
Hmm.
Honorable Guwahati High Court in the above cited decision held that in a suit for rejectment of a tenancy, the plaintiff fails to prove the relationship of landlord-tenant but proves his title. The court has discretion under Order 7, Rule 7 of CPC to grant equitable relief of rejectment on the basis of title, provided that the plaintiff has done nothing but disqualified himself from receiving equitable relief, and the issue of title has been raised and fairly tried. In the present suit, the defendant raised self-contradictory plea. In one hand, defendant raised plea of adverse possession, and in the same pleading, in para number 10, pleaded that owner of the land entered into an agreement to sell the suit land to occupier at a consideration of rupees such and such, and the sum of rupees such and such was taken as part payment, but did not sell the suit property. The defendant failed to prove his adverse possession as well as the plea under Section 53 of the Tenancy Act to protection and state. So that aspect also.
No, but will that factor that there was in the meantime a move to sell the suit land to them, will it come into the way of adverse position?
Because why I'm submitting this note? Because of the fact that in the written statement, to some extent, they have denied these persons are the owner of the land. And the
No.
erosion part is there. They came into possession of the land. They made certain construction and thus started deciding
See,
there.
Mr. Chaudhary, the defense of adverse position is always against a owner, against a person who has the papers in his favor.
Exactly.
So whether they are admitting or denying, the once they take the defense of adverse position, it amounts to admission of the papers in favor of the original owner.
Yes.
But in spite of that, adverse position will be a valid defense if they are able to produce in the court that in spite of the equities, I have been in position adverse to the interest of the original owners in open assertion of my rights for more than 12 years. Their admission that yes, this persons were the original owners having papers in their favor, that will not make their case weak if otherwise they are able to make out a case of adverse position.
Because the tenancy part, because why I'm referring to this particular paragraph law, the tenancy part, Honorable Court has observed that once the ownership is there, the tenancy, since I'm just submitting law, since PW2 has made a mention with regard to the tenant. So that aspect in the cross-examination also, there is no this
So the context in which this 8 and 9 has been discussed and the decision of this court has been laid down, that was, it appears that it was a dispute between a landlord and a tenant.
Yes.
And
with
while,
regard to because
And one of the
subsequent
players were
purchase,
not there
yes,
for the rejectment. So court said, yes, 7-7, we can,
equitable relief.
yes, we can grant.
So subsequently, the person who has purchased the property
Okay.
and the person who is in possession of the property.
Okay, we will close this. We'll apply our mind. We could have dictated. Have you found Goa and Ungo?
Yes, Goa and Ungo, my lord, this is the notice sent by the advocate, authorized by the power of attorney holder to this, my lord. One is Jagan Singh, who is the original and my lord, one to the Nandan Chauhan, who is the defendant. And my lord, I'm reading for the relevant portion. That at the time of delivering the vacant.
Which page?
No, it's from evidence.
No, which page?
It is, my lord, file
File what? C2?
C1.
C1?
C1. File C1. My lord, page number 72.
Okay.
72 and another page 74. In both this, it is stated, my lord, that at the time of delivering the vacant and past possession of state plot of land unto the state purchasers by the state vendors, namely Sri Anantaram Agarwala and Sri Vijay Kumar Agarwala, in presence of my client, the legal attorney of the state purchasers and other witnesses, you have been found occupying illegally a portion of the plot of land. Occupying illegally a portion plot of land. They're not saying 10.
They might construe that not paying of rent is illegal occupation.
They're on it.
As a tenant, you are supposed to pay rent. The moment you don't pay rent, You're in illegal occupation. You have done an illegality. Page 72 and 74,
Yes, but
file C1, okay.
exhibit third.
Third, Sri A.K. Gupta, learned counsel for the. Oh, it is yet a decoration, okay? Yet a deduction. We will pass the judgment right now. Otherwise, we don't want to increase the burden in the chamber. Already we have 2, 3. And third narrative. The present second appeal is preferred against a judgment and decree dated 14/7/2008 passed by the learned additional district judge number 2 FTC Tinsukia in title appeal number 11 of 2003, by which the judgment and decree dated 29/4/2000 passed by the learned civil judge junior division number 1 Tinsukia in title suit number 107 of 1993 has been reversed. Full stop. The present appellants were the defendants in the suit which was instituted for declaration of right, title and interest and ejectment. Full stop. Para. This court wide order dated 15/9/2008 had framed the following substantial question of law. Page 15/9 or order sheet or দুটো আছে যদি এটাই আছে কিন্তু সেকেন্ড এনি আদার কোশ্চেনস তো না লাগে এটাই দিব এই বলে Para. I have heard Sri A.K. Gupta, learned counsel for the appellant, whereas the respondents are represented by Sri S.P. Chaudhary, learned counsel. Full stop. The LCR, which LCRS, lower court records, which have been requisitioned, have also been perused. Full stop. Para. The learned counsel for the appellant has submitted that the basis of filing the suit, of instituting the suit, was a sale deed number 11 of 1984 executed in the year 1984, by which the plot of land, the suit land, was purchased by the plaintiffs from the original owners. Full stop. It has been projected in the plaint that the defendant number 1 was a tenant of the original owners who had also inducted the defendant numbers 2 and 3 subsequently to the suit premises. Full stop. It has been averred that upon purchase of the land in question, comma, the defendants were found to be in illegal occupation, and accordingly, the title suit was instituted in the year 1986. Full stop. The sale deed has been exhibited as Exhibit 2, and the plaintiff side had adduced evidence by 3 numbers of witnesses, including the PW1 being the power of attorney of the plaintiff number 1. Full stop. Para. It is submitted on behalf of the appellant that a joint written statement was filed by the defendants, and by referring to the averments made in paragraph 10 of the written statement, comma, it has been contended that there was a denial of the fact of tenancy. Full stop. It has also been averred in the said paragraph that the defendants were in adverse possession of the concerned land in question for the last about 30 years. Full stop. Para. The learned trial court, by judgment and order dated 29/4/2000, had however dismissed the suit. Full stop. The learned counsel for the appellant has submitted that amongst the issues framed, comma, the relevant issues are issue numbers 2 and 6. Full stop. Whereas issue number 2 is with regard to the aspect as to whether the plaintiffs are the owners of the suit premise, comma. Issue number 6 was on the aspect as to whether the defendants were tenants under the plaintiff by operation of law. Full stop. Para. The learned trial court had come to a finding after discussion of the evidence on record, including the deposition of the PW2, that there were no materials regarding tenancy of the defendants with the original vendors, and therefore the aspect that the defendants were the tenants of the plaintiffs could not be proved. Full stop. As regards the issue number 2, comma, the learned trial court had come to a finding that since the year 1958-1959, the defendants were occupying the suit land adversely to the interest of the original owners, and therefore, after about the year 1970, the right of the original owner had extinguished. Full stop. This suit was accordingly dismissed. Full stop. Para. Sri Gupta, the learned counsel, by referring to the judgment of the First Appellate Court dated 14/7/2008, has, however, submitted that while reversing the findings on the aforesaid two issues, the evidence on record were not properly appreciated, and the findings are more on conjectures and surmises. Full stop. It is submitted that so far as the aspect of atonement by the defendants, that the plaintiffs were the landlords, it is submitted that at no point of time there was any atonement from the side of the defendants to consider the petitioners, the plaintiffs, to be the landlords. And in any event, they were never the tenants, even of the original vendors. Full stop. By drawing the attention of this court to the original records, more particularly exhibits Gho and Ungo, GHA, UNGA, which were relied upon by the plaintiffs, it is submitted that those notices were issued by the learned counsel for the plaintiffs to the defendants, wherein the defendants were not termed as tenants, but as illegal occupiers. Full stop. He submits that from the own admission of the plaintiffs, which would reflect from such notices, the plaintiffs would be precluded from taking the from taking support of the plea that the defendants were the tenants of the original vendors, and after the sale, by operation of law, they had become the tenants of the plaintiffs. Full stop. The learned counsel for the appellant accordingly submits that the appeal is liable to be allowed and the judgment and decree of the trial court is to be restored. Full stop. Para. Per contra, Sri S.P. Chaudhary, learned counsel for the respondents, has submitted that the findings arrived at by the First Appellate Court are based on materials on record. Full stop. By drawing the attention of this court to the evidence of the plaintiff witness number 1, it is submitted that the aforesaid evidence would show that the transfer of title from the original vendor to the present plaintiffs through the sale deed number, what was the number 1? Or sale deed number 11 of 84, which was exhibited as Exhibit 2, was not even the matter of challenge in any proceedings. Full stop. Reference has also been made to the evidence of the PW2 Anantaram Agarwala, who was one of the original vendors. Anantaram was one of the vendors, one of the original vendors, who had deposed that the defendants were indeed the tenants of the original vendors. Full stop. It is submitted that in view of such materials available, the findings arrived at by the learned First Appellate Court cannot be found fault with, and accordingly, the present appeal is liable to be dismissed. Full stop. Para. The learned counsel has also submitted that the First Appellate Court in the judgment had taken into account the law settled by various judicial precedents on the point of atonement of tenancy as well as adverse possession. Full stop. It is submitted that there being materials on record that the defendants were tenants of the original vendors till the purchase in the year 1984, even if the said defendants deny the aspect of atonement, the suit being instituted in the year 1986, the defense of adverse possession would not be available to the defendants, appellants, as such defense has to be construed qua the party in the suit. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court, including the LCRs, have been carefully examined. Full stop. While the plaintiffs have related their right over the suit land on the basis of sale deed number 11 of 84, the defendants have taken the defense of adverse possession over the suit land. Full stop. Para. We'll include a para on adverse possession. The plea of adverse possession, as discussed above, is a defense, and such defense is recognized by law on fulfillment of the criteria mentioned above. Full stop. The aspect as to whether aspect of the legality of the sale deed by which the present plaintiffs had acquired, by which the title was transferred to the present plaintiff would not be a relevant factor inasmuch as the defense taken in the suit is of adverse position, and therefore the question as to whether such sale deed was the subject matter of challenge or not would not be relevant. Full stop. There is no materials on record or even the pleaded case to suggest that the defendants were the tenants of the plaintiffs. Full stop. In fact, the pleaded case of the defendants in the written statement is that not to talk about tenancy under the plaintiffs, they were not even the tenants of the original owner. Full stop. For ready reference, the pleadings made in paragraph 10 of the written statement is extracted herein below. Full stop. The question therefore would arise as to whether the aforesaid pleadings relating to a defense of adverse position could be established as a valid defense at the time of the trial. Full stop. The plaintiffs came into the picture by virtue of the sale deed of the year 1984, and the suit was instituted in the year 1986. Full stop. However, the pleaded case of the defendant is that they are in adverse possession of the suit land and the suit premises since the year 1958-59. Full stop. The plaintiffs had adduced evidence by 3 witnesses, and towards the issue of adverse possession, it is the evidence of PW2 which should only be relevant, as the version of the other 2 witnesses are hearsay on the aforesaid aspect. Full stop. PW2 is Anantaram Agarwala, as indicated above. Full stop. He had deposed that the defendants were tenants of the vendors of the plaintiffs. Full stop. However, in his cross-examination, he had deposed that he had replied that though in his income tax returns, there was reflection regarding rental income, he is not aware as to whether such rental income had also mentioned about the rents obtained from the present defendants. Full stop. This court has also noticed that exhibit Gho and Ungo, which are notices, which are legal notices issued to the defendants, have termed the said defendants to be illegal occupiers. Full stop. Under those circumstances, comma, this court is of the considered opinion that the findings arrived at by the trial court in its judgment dated 29/4/2000 cannot be said to be perverse and are rather based on the materials on record. Full stop. The learned trial court, comma, as observed above, had come to a finding that there were no materials to come to a conclusion regarding tenancy with the original vendors, coupled with the fact that it was the categorical assertion of the defendants that they are in occupation of the suit land since 1958-59, adverse to the interest of the original owners. Full stop. This court is therefore of the view that the impugned judgment and decree of the first appellate court dated 14/7/2008, by which there was a reversal of the judgment of the trial court, is not sustainable and accordingly sustainable. Full stop. Para. The substantial question of law as framed by the order dated 15/9/2008 is answered accordingly by holding that the finding of the first appellate court on the plea of adverse position is not based on materials on record. Full stop. The appeal accordingly stands allowed, and the judgment and decree of the Civil Judge Junior Division number 1 Tinsukia is restored. Full stop. Send back the records immediately. We'll include one paragraph on adverse position, the law. Okay.
Okay.
I think 16, 19.
Apologize, Lordship. The last speaker could not appear.
Yes, yes.
Lordship, their application is barred by a limitation. Time period is 30 days. They have filed almost after 1 year.
For restoration,
For it,
they have cited some reasons.
no written specific reasons. For
No, the advocate was not aware.
advocate, they have simply stated the same thing twice.
No, but if they are not informed by the advocate, then will it be proper?
And Lordship, further, he has not specified the exact date on which he came to know. And further, Lordship,
See,
the
a dismissal of case without going to the merits, that may not be in accordance with law. Let it be adjudicated on merits.
but Lordship, the main issue is he has remarried. He, after 8 months of
Who, your client?
my time.
That will
Yes.
take care. Yes, what is there?
And,
No, see,
and-
his marrying again was at a time when there was no case.
Well.
There was no stay order. He has got a divorce decree. He is entitled to marry. And after 6 months.
After 8 months.
So they are not stating, they will.
I have stated it now.
matter
And you are saying that you are staying together.
No, Lordship,
Together.
they are staying in the same premises, but illegally she is staying in another room, not in the same house. It is a
Same house.
separate accommodation and they are taking steps for eviction.
No, this will be a relevant factor in the decision of the main case. But here, let us restore it. And okay. Third, Sri B.K. Das,
Ma'am.
learned counsel for the applicant. Also heard Sri
A.
A.
Kakuti.
Kakuti,
A.
learned counsel for the opposite party, who has also filed written objection, full stop, para. By the instant application, comma, the applicant has paid for restoration of IA civil on a restoration. What was the original IA? For delay condonation?
For delay condonation.
IA civil 683 of 2019, along with the connected appeal, which was dismissed for default on 29/2022. Full stop. It is submitted that the engaged counsel had defaulted in appearing, leading to dismissal of the said IA, and the fact of such dismissal was also not informed to the applicant. Full stop. However, on coming to know about the same, comma, the present miscase has been filed for restoration. Full stop, para. Per contra, comma, Sri Kakoti, the learned counsel for the opposite party, by drawing the attention of this court to the affidavit in opposition filed on 3/6/2024, has submitted that the restoration petition is itself barred by time. Full stop. It is submitted that that there is a prescription of time for filing such restoration application, and the same has been filed long thereafter without any explanation. Full stop. Without any explanation. Full stop. He has also submitted that there should have been a separate application for condonation of delay, which is also not filed. Full stop, para. The rival contentions have been duly, Sri Kakoti, the learned counsel, has also informed that after the decree of the divorce, comma, his client has remarried, and therefore the appeal, which is yet to be registered, has become infructuous for all practical purpose. Full stop, para. The rival contentions have been considered. Full stop, para. The restoration application. Now, it appears that the restoration application has not been filed within the prescribed period of limitation, and therefore it appears that there is force in the argument on behalf of the respondent that unless a further application for condonation of delay is filed, comma, the same cannot be entertained. Full stop, para. This court has, however, noticed that the reasons assigned in this petition for restoration, as would appear from paragraphs, from the averments made in paragraph 3, comma, the interest of justice would require that a fair opportunity be granted to the applicant to present her case, at least for condonation of delay, in preferring the original appeal. Full stop. Para. The instant MC accordingly stands allowed, and the IA number 683 of 2019 is restored to file. Full stop. This court would, however, take into consideration the fact of remarriage of the opposite party after the divorce at the appropriate time. And in the main, in the IA, right? IA Tasana. And this IA has, which IA which was dismissed for default on so and so has been restored to file via an order passed today, that is so and so. In miscase 78 of 2022, full stop. The IAB accordingly listed for consideration after a week.
Obliged.
The item number 12, Lordship, can it be taken up
12 is what?
hearing?
No, 12 is what matter?
MSc.
MSc, okay. What, you are for the appellant? What is the problem?
There is no problem, as such, Lordship, it will take time today, I'm not.
You have some problem today? Okay. Otherwise, we would have taken up the matter. Yes, you are for the other side.
Yes, I'm the respondent number.
What is the
Payment.
appeal about?
This is the allegation of fraud.
Okay, you are,
I have filed an affidavit. The Honorable Court had asked me to file some documents. Inquiry,
filed-
matter is re-investigated and RTI, to RTI, all these documents.
you have filed.
I have filed.
Okay, whenever you say, when do you want, tell us?
Any? 25th of
25th, last week. You know what will happen last week. We can have it next week.
Yes, sir.
Today is what? Today is 6th. We can have it on 13th.
Nothing, yes.
13th, Mr. Goswami?
It was 12 or 14. 13.
12, okay, 12. We'll try on 12. Okay.
Sure.
12 is a, no, okay, let's try on 12. On a prayer made by Sri R. Goswami, learned counsel for the appellant, list on 12/6.
Yes. Right. Problem.
May please your lord.
Yes.
Matter we possible for a time being lord. Senior Mr. Sahiola will take it.
Okay, please call him 12 matter after a while. What is the matter to us?
It is just second appeal.
That we know. What is the subject matter?
Lordship, we filed a suit for recovery of 2,08,019 from the ONG for some contract works and there. So we have filed that suit for recovery of this money along with the earnest money and for illegally rescission of the contract by the
You
ONG.
have sought compensation also,
Yes.
damage also.
Yes.
Okay, then,
Then
Decreed.
filed it, so that was dismissed.
okay.
Then we filed a appeal. That was allowed.
Reverse in the appeal.
Yes. So now
Oh.
that's come.
What are the grounds of challenge?
The show cause notice which was issued by them, we did not receive that show cause notice in time. As a result, we could not reply. So as we could not reply, we did not get the chance to rebut. And principles of natural justice was not followed.
Ultimately, how much is the amount involved?
Prayer, where has stated 2,08,000
Why don't you
019.
settle this kind of matter, Mr. Das? 2 lakh matter, you are fighting in the High Court, ONGC.
And your lordship, 50% has already been deposited. 45.
Dispute is regarding the completion of work, lord.
Regarding the
Completion of work.
completion.
They have stated that the 97% of the work has been completed. But our side is that no 97%.
Now, those disputes have been resolved by a civil court.
And
Unless you can show that such resolution is perverse to the materials, then perhaps there will be no scope of interference.
your lordship, they failed to adduce any evidence. That is one.
Ultimately, the amount involved is not a very big amount for ONGC, 2 lakh. Why do you? Okay, well, let him come.
Obliged.
6, I think 6.
But this is wrongly listed for hearing. My lord, what happened in this case, my lord, 2 of the respondents died. My lord. So I have filed the substitution applications, my lord.
Number?
Lordship, may kindly take up miss case number 1191 of 2014.
This is for restoration or what?
No, my lord, substitution.
Why is it pending?
My lord, what happened, my lord, during the pendency of the appeal, this person died, my lord. But this petitioner do not have any knowledge, even at the time of filing this revision petition, we do not have knowledge. Only when the notices were issued, we come to know that they died, my lord. Thereafter, this, my lord, substitution applications were filed. The respondent has raised the objection that since they died during the pendency of the appeal, so this substitution cannot be done at this stage.
You have to file order 10.
I have filed both, my lord.
Order 10
subsequent-
was there.
Order 1 Rule 10, I have also filed.
Order 1 Rule 10.
Order
for-
1 Rule also
yes.
filed.
Because if during the pendency of the appeal, somebody passes away, you file substitution. But if before institution of the appeal, filing of the appeal, then it is just to be adding of new parties.
Yes. So I have filed also one, there is another, my lord, mistake for
Under
that-
110.
Order 1 Rule 10. But there are there are two
Who
views,
is on the other side?
my lord, Miss P.
Who's-
Burman appears, my lord.
Who?
Miss P. Burman. She was there in the first. On the last August, but she was not there.
Mr. P.K. Burman is there, D. Das is there. Can you look at them? We'll have Mr. Sahiwala's matter in the meantime. Mr. Datta, yes.
Well, this is judgment of reversal. Lord, the only substantial question of law, came if the Lord will see whether the first appellate court was
Which
justified.
order? Which order?
My lord, that is order. Just given. Order that. I'm just. Yes, 19/3/13, my lord.
Not 19/3, 11/6. 11/6/13.
Oh, 11. Yes. Whether the first appellate court was justified in declaring the suit of the plaintiff by holding that plaintiff has completed 90% of the work by 10/11/95, ignoring the stipulation of the work order that 5/9/95, Exhibit 5, relating to the period for completion of the work. My lord, what happened, my lord? On 15/9/95, work order has been issued by.
Just a minute, whether the first appellate court was justified in decreeing the suit. Was had come. Appellant is the defendant.
Appellate.
Suit for?
Suit for, my lord, declaration and realization of the amount, my lord.
Suit for recovery.
Recovery.
What happened thereafter?
My lord.
Suit was initially dismissed, rejected.
Dismissed. Then appellate court, my lord, on wrong appreciation of the fact, my lord, has decreed.
What is the order of the first court?
Trial court. Yes, my lord. Your lordship, see the issue number 4 and 5.
Page?
My lord, I'm just coming, my lord. Judgment starts at page 16. Issue number 4 is page 21. 4 and 5. What is the-
Just give us two minutes.
It appears
Just record something. 29 August.
entire facts is there in.
29 August 2011 is the order of the judgment and decree of the appellate court.
My lord.
Correct?
Yes. 29/8/11.
Yes, this is the titled appeal 35
Yes.
of 2006. This is by which court? Which? Additional district judge. Achha. Initial judgment and decree is 29/6. 2006. In title suit number 102. 97 by civil judge
Number two.
Two.
Karnataka.
Pachar. Okay, now tell us, where do you want us to go?
My lord, your losses may come to page 21 of the, my lord, trial court judge,
Of the first court judgments.
first court judgment.
Where will you get?
Page 21, my lord, of the memo.
Okay.
It appears that exhibit 1, the work order dated 15/9/95, that
Where are you reading?
issue number 4 and 5. Last
Page
page 21, my lord.
of the trial court judgment.
No, yes, trial court judge. Internal page 6, my lord.
Just a minute, please. Twenty-one. Issue number 2,
4 and 5.
4 and 5, oh, paragraph 9.
Yeah, 9.
Okay,
So far, that is concern nothing.
4 and 5, yes, please.
It appears that from exhibit 1 that the work order dated
This
15/9/95.
is the trial, first court, trial court.
First court.
Okay. Yes, please read.
It
It
appears that exhibit 1, the work order dated so that immediately within 7 days, the work order, formal agreement will be executed by the plaintiff. But the plaintiff did not execute any such agreement within the period of 7 days. The state work order shows that time for contract work is 1 month, 6 days, which will be started from the 3rd day of the order. So, my lord, if your lordship will see 15/9/89, so time for completion is 24/10/95. That may be recorded, my lord. 24/10/95 is the time for completion of the work. So it is there, my lord. So from the perusal of exhibit 1, it appears that within
Oh, which
24
which date you have just pointed it out? So the contract was 1 month and 6 days.
6 days. So from the perusal of exhibit 1, it appears that within 24/10/95, the work order has to be completed.
Okay. What was the work?
My lord, the work is, my lord, it is construction of the ring, pond and earth filling. It is a very urgent, my lord, at the time. In GS area, my lord.
Okay.
So exhibit 1 appears that within, so from the perusal of exhibit 1 appears that within 24/10/95, the work order is to be completed. Exhibit 4, the letter dated 5/10/95 issued by different number 4 shows that the plaintiff did not enter into an agreement till that day. My lord, they have to enter into agreement within 7 days. But till 5th of my lord, no, October, they did not enter into agreement. The plaintiff did not enter agreement till that day, and also did not start any work till the issuance of the said letter. And as such, different number 4 issued the said letter, directing the plaintiff to execute the work as it is urgent one, otherwise threatened to cancel the work order and forfeiture of the earnest money. The plaintiff's letter dated 10/11/95, that is exhibit 2 and 5, itself shows that he claimed to have completed only 97% of the work and not the whole work of the contract agreement. The period of contract has already discussed is up to 24/10/95. There is nothing on record that the time of the contract was extended by the defendant. The plaintiff claimed that though he did the 97% of the work, informed the matter to defendant number 4, 5, letter dated 10/11/95 and 13/11/95, that exhibit 2 and 5. The defendant number 4 cancelled the work order. The defendant claim on the other hand is that the plaintiff, though was supposed to start the work in the 3rd week of the month of September 1995, yet he did not start the work. And in spite of repeated requests to start the work, even after entering into a formal order agreement on 6/10/95, failed to execute the work. Exhibit 4, data 5/10/95, the plaintiff's own documents show that plaintiff did not execute any work order till 5/10/95, in spite of the work order issued on 15/5/95. The plaintiff did not agitate the contents of Exhibit 4 in any way. Thereafter, the defendant issued data 2/11/95, Exhibit 6, alleging non-starting of the work and threatened to cancel the work order and forfeiture of earnest money if reply of the show cause not given within 7 days. The plaintiff claimed that he has received the show cause notice on 11/11/95, and prior to receipt of letter of the show cause, he issued a letter that 10/11/95, Exhibit 2, stating about completion of 97% of the work. It is the claim of the plaintiff that he could not file show cause as per letter that so and so. Exhibit 6, the defendant within 1 week, as he received the letter on 10/11/95. So it appears the plaintiff, though admitted receipt of the show cause letter 2/11/95 of the defendant, he has claimed to have received the same only on 10/11/95. As the plaintiff has taken a specific plea regarding the receipt of the letter 2/11/95 on 11/11/95. Hence, it is the burden of the plaintiff to prove the state fact. He could not have called for ID card, etc. Defendant or could not have called for postal document from the post office to prove the state fact. But he
But
did-
Mrs. Sayal, are you disputing that the plaintiffs could complete 97% of the work?
No, that, so my lord, we have asked him for measurement. Whatever work he has done, he will get it.
Oh, yes, that
My
is,
lord, so he did not appear, we have measured the work and we have paid,
we have paid also.
my lord. My lord, main thing is this, the work order has been cancelled, but whatever he has done, that,
How much payment have you
I
made?
don't, that I don't know, my lord.
But your instructions is that
Yes, my lord.
whatever
They have
work,
measured the work, my lord, the telegram, my lord, to him, to come and to, for the purpose measurement. Normally, my lord, this is done.
but your clear instruction is that whatever work has been done, you
Yes,
have paid.
yes.
What was the finding of the first appellate court?
First appellate court has done, my lord. If your lord will come to my lord, issue number 4 and 5 is at page 34. Your lordship may come to page 35, para 11. Other facts are admitted,
Yes.
but the evidence of the plaintiff reveals that after entering into agreement, the defendant on 6/10/95, he started the work on 8/10/95. And he completed 97% of contract work by his letter that 10/11/95. Well, this is also wrong, my lord. It is 10/11/95. Exhibit 2. He has wrongly quoted my lord 10/10/95. And he informed the defendant number 4 in response to a letter dated 6/10/95 about the progress of the work and assuring that he would complete the remaining work within short time. He also requested the defendant number 4 to make necessary arrangement for payment of his up-to-date bill. His evidence also revealed that in spite of he received proper notice from the defendant on 11/11/95 and 30/11/95, he sent a letter to defendant number 4 informing about the progress of the work and undertook to complete out of the work. But despite the defendant number 4 resist the contract on 30/11/95, the plaintiff has exhibited series of photographs with negatives as exhibit 2 and 21 to 527 challans supplying art to support him. GK Prakash Learned Counsel for the defendant submitted the exhibit 8 and 21 to 527 are not admissible in evidence. Challans bears no signature of the defendant, who is according to him prepared by the plaintiff himself. As such, the claim of the plaintiff that he completed 90% of the work hold no water. Prakash further submitted that no document relating to payment of the land compensation forest royalty were produced. The RC of the vehicles used in carrying art, logbook, payment register also has not been produced, and the examination of the same, it is difficult to arrive at a conclusion. Prakash further submitted that the photographs are also not admissible as the plaintiff has failed to start the complete the work in time and also failed to furnish so-called reply. As the defendant court extended the work on 13/11/95. In view of section 55 of the law of the contract, the burden to prove the completion of 97% of the work lies upon the plaintiff that he failed to discharge the same. Procast of further submitted that there is no infirmity in finding of the fact by learned trial court and there is no ground for interference. Where the DKDF learned counsel for the appellant
Come to
submitted,
the finding,
my lord,
come to the finding, these are
Yes.
submissions.
no, my lord. Para, my lord, para 15, my lord,
1-5,
that's page 38.
yes.
We find submission of DKDF got sufficient force. There is no evidence on record to rebut the version of plaintiff that he has completed 97% of contract work. Exhibit 2 and 3 letter of the plaintiff, exhibit 8, 11, 21, lends assurance to the claim so made by the plaintiff. Defendant failed to conduct any inquiry before rescinding the contract work and the later dated so. For the defendant bears no such indication. There is no evidence to show that plaintiff received the so-called letter in time. As such, he could not submit the reply. It also emerges from the contract work has been rescinded without hearing the plaintiff and giving him opportunity of explaining the circumstances as to why he could not complete the work, as he admitted that he has done some of the work. Thus, the mandate of clause 3 A, B, C of the contract book standard so has been complied with stated and strict, and as such, it has been made arbitrarily in contravention of the state clause and the principle of natural justice. That being the position, the finding of the learned below is number 4 and 5 erroneous, and the same requires interference. Accordingly, state the finding of the learned court below on 2 issues. We find that hold that order terminating the contract is legal void. Well, even as per his own admission, he has not completed the work. That is to be completed on 24/10/95. Even on that day also he has not completed. So termination, how it can be held to be illegal, my lord? If any work is done, my lord, he is entitled only. Termination is legal, my lord. Termination cannot be said to be illegal.
Mr. Datta, have you got the payment for the 97% allegedly done?
No, Your Honor.
Huh?
Only as per the order passed by this honorable court, they have deposited 50% of them.
No, that is a different matter.
Otherwise, we have not got.
You pay for the amount they have.
Whatever work has been done, that will be paid, my lord.
Because 97% we have completed. That has been established by evidence. And they have not, apart from the written statement filed by them, they have not filed their evidence. Now, whether they can take all three at this stage,
My
that is
lord,
the question.
Telegram
Not
has,
the appellate stage also, they could have not taken any plea.
my lord, there is a exhibit with Telegram received your about so you are requested to remain present at site at 11 AM on 18/11/95 for
No,
taking
Mr.
measurement of the job.
Mr. Sayal, as per you,
Yes.
what is the amount of work which they have done, as per you?
Lord,
Yes. Mr. Das, please take instructions. These matters, I don't think this should be matters of adjudicating long hearing.
My lord, correct.
Whatever is,
Yes, yes.
they have worked.
Any work is done, my lord,
And
that
since Mr. Datta is asserting that they have not
Yes,
received the payment, and 50% you have already paid here, what was the decree amount?
Total amount was 2,08,000.
Around 1 lakh paid, or some maybe around some 60,000 would have to be paid. We'll direct the ONGC to pay, but ascertain from your side.
My lord.
We don't want arbitrary order to be passed.
My lord.
As per your instruction, what is the progress, not progress, the work done, the percentage of work done? And we'll.
Naturally, my lord.
Heard Sri GN Sahalal and Senior Counsel, assisted by Sri T. Das for the appellant, whereas Sri S. Datta, Learned Counsel, is present for the respondent. Full stop para. During the course of deliberation, an issue has cropped up regarding the percentage of works completed in connection with the contract in question, full stop. The Sri Das, Learned Counsel, assisting the Learned Counsel for the appellant, assisting the Senior Counsel, is accordingly directed to seek appropriate instructions in this regard. Full stop, depending upon the same comma, this court would make an endeavor to finally dispose of this matter by directing payment, by considering passing of a direction for payment for the works done, subject to further deliberation. That is one of the tentatives. List when?
After 2 weeks, my lord.
List after 2 weeks.
My lord, the date is fixed.
Matter of yes, 2012. You date. Days 7th. Adi 6th no, 2 weeks. And we'll have it on 28th 20.
Right.
This
Okay.
20 June. Yes, madam, something, what is it? Some restoration application,
Yes, sir. The substitute,
one substitution, one for, one under order, one rule 10.
yes, sir. Subsequently, earlier it was filed under
No, if they had come to know
Yes.
that the person had passed away even before institution of this revision,
Yes.
then we can consider 110 substitution may not come. It is not a pending proceeding before this court. What about 110? You have any objection? No objection, I think.
No, in this case, filed the objection. In earlier mistakes, we have filed the objection.
Okay.
Earlier,
What is the I for under order 1 rule 10?
IS civil number 2387 of 2021. 2387.
Okay. You have been served with a copy, madam?
Yes.
2387, please.
I think, 2011, or respondent number 3 and
Has
4.
no legal only competent.
But I have prepared a list of dates.
You are for Prasanna and Lankeshwar?
Yes.
What is your, any objection?
In case, if earlier I mistakes or we have filed objection.
No, here.
In this case, we have not filed any objection, but in this case,
I don't think
filed.
you would have any objection. You are there, you'll be heard.
Yes, sir. For that, on the objection for 2011 for some, reference of 3 and 4 died, sir. And during the pendency of this appeal, sir.
Not pendency. It was before institution of the revision.
No, Lordship, earlier,
Who had passed away? Prasanna,
Prasanna and my lord, another.
Lankeshwar.
Lankeshwar.
3 and 4, 36. Lordship, Miss appeal is dismissed on 16/3/2013.
For?
Prior to that, Lordship, in 2011, the respondent number 3 and 4 died.
Lord, I have prepared a list of dates, and that will be better to describe the facts. My lord, in this case, my lord, 6295.
Who are you, Mr. Gupta?
I am the defendant in the suit, my lord.
You are the defendant.
Yes.
Yes.
This Samiti is the defendant.
My lord.
Or the Brahmputra.
Brahmaputra Sambai Samiti.
And Mangaldo is
The plaintiff.
Thank you.
Okay, then that is.
6295, title suit number 8 of 95 filed by the opposite party.
Mm.
Then my lord, 8796, ex party judgment was passed.
Mm.
Then my lord, 16608, mistake case was filed under order 9 rule 30.
913, okay.
Then my lord, 4509, miscase was dismissed. 18110, misappeal was filed.
Mm.
Then my lord, 28/6/2011, respondent number 4 died. Then 14/10/2011, respondent number 3 died.
Mm.
16/3/2013, misappeal was dismissed. 17/6/2013, CRP.
Okay, now understood. Now during the
Pendency of
during
pendency of the
the
misappeal.
pendency of the misappeal, you did not take steps for substitution.
No, I have made a specific avertment that during pendency of the appeal, it is not informed that this person died. Because the councils have.
And you have filed this revision against dismissal of the misappeal.
misappeal. And my lord, only the notice, when the notices were issued, my friend appeared, my lord, then she informed that this person's died. Then initially one mistake was filed since the
The appeal was against order 9, rule 13 order or against the initial decree?
order 9 rule
Order
13.
Okay.
Initially, in lordship, it titles to construct, they have filed written object, written set, lordship subsequently they have not appeared, but according to the suit was a dictate expert.
No, that is okay. We are not going into the merits. We are only considering the issue of addition of parties.
Yes.
Okay. Heard. 3 A.K. Gupta Learned Counsel for the please tell us why, what is 1191?
My lord, these are filed under order 22.
Substitution.
My lord, this 1191 is a section 5 application
Limited delay.
for delay
In?
in filing the substitution application. The
Okay.
Initially,
This
my-
will go, this will go.
this I will not press if
This
lordship
this will
allows
go,
this.
this will go. 119 is okay, section 5 for substitution.
Yes. 1191 is section 5 for delay condonation.
Section 5
119.
for substitution. Then
1192 is for
1190
1190 is for substitution.
substitution. 1192
1192 for setting aside abatement.
and 2387
2387 is under order 1 rule 10.
order 1 rule 10. Okay, very good. You could have filed 2-3 more cases.
But under by mistake I have filed. But later on I come to know about the
Okay,
judgment.
right, huh? এই গুটি কেইটা আহিব দে সব কেইটা এটা মিছ কেছ 1191 চাই ল'বা 1190 সব মই কৈ দিম the heard 3 A.K. Gupta Learned Counsel for the applicants in these miss cases and whereas MSD Das Burman has appeared for the
Respondent.
respondents. Full stop. By this common order, comma, all the aforesaid miss cases and are being disposed of. Full stop. However, it would be convenient if the background of these cases are put in brief para. The applicants are the defendants in title suit 8 of 1995, which was decreed ex parte on 8/7/1996. Full stop. Accordingly, an application under order 9 rule 13 of the CPC was filed for vacating ex parte judgment and decree, and the said petition was however dismissed on 4/5/2009. Full stop. The applicants had accordingly preferred miss appeal number 8 of 2009 against the order dated 4/5/2009. Full stop. Though during the pendency of the said appeal, the opposite party numbers, the respondent 3 and 4 in the connected CRP 355 of 2013 had passed away, comma, the counsel conducting the appeal was not aware, and accordingly no steps for substitution could be taken. Full stop. The miss appeal 8 of 2009 was however dismissed on 16/3/2013. Full stop. The present CRP 355 of 2013 has been filed assailing the aforesaid order. Full stop. At the time of during the pendency of the CRP, comma, the fact of the death of the respondent was 3 and 4 could be detected, and accordingly, comma, initially MC 1190 of 2004 was filed for substitution of the aforesaid two respondents. Full stop. Since the matter was abated, comma, MC 1192 of 2014 was filed for setting aside abatement, and Miss Case 1191 of 2014 was filed for condonation of delay. Full stop. Para. After filing of those application, comma, it came to light that the aforesaid respondent numbers 3 and 4 had died even during the pendency of Miss Appeal number 8 of 2009 and prior to the institution of the present CRP. Full stop. Accordingly, comma, IA number 2387 of 2021 has been filed under Order 1, Rule 10 of the CPC for addition of parties. Full stop. Para. Sri Gupta, the learned counsel, has submitted that the presence of the legal heirs of the respondent numbers 3 and 4 would be necessary for a fair adjudication, and they are necessary parties. Full stop. He also clarifies that the connected miscases have become infructuous and no orders are required to be passed in those, and only IA number 2387 of 2021 is required to be considered, which is for addition of parties. Full stop. Para. Ms. D. Das Burman, learned counsel for the respondents, has fairly submitted that though the earlier approach of the applicants in instituting in filing applications for substitution was not correct, as such substitution was not maintainable, comma, she would not have serious objection to the IA for adding up the legal heirs of the respondent was 3 and 4 in the connected CRP. Full stop. Para. After considering the rival submissions, comma, this court is of the considered opinion that the legal heirs of respondent numbers 3 and 4 who are sought to be impleaded are necessary parties, and their presence would be necessary for a fair adjudication. Full stop. Accordingly, I so and so stands allowed. And who are they? And who are the legal heirs?
If I have it. In the first letter, their names are there.
Page.
Page 4, page 4 of IM.
And in place of respondent numbers, who is Prasanna is 3.
3 months.
In place of Prasanna Rajbangshi, within bracket, respond number 3, comma, the, his legal heirs who have been named in the cause title. You should have given a paragraph. Be cause title, namely, it likh diba, huh? It way. Namely, huh? Be added as respond numbers 3A, 3B, 3C, and 3D, and for respond number 4, comma, the following, namely, huh? So and so, it will be, huh? Be added as respond numbers 4A, 4B, 4C, and 4D in the CRP, full stop. All the learned counsel for the applicants is required to file amended cause title in the connected CRP, full stop para. All the aforesaid missed cases and IAs accordingly stands disposed of. অকল IA টোৰ পৰা নাম পাব দে। এইটো হ'ল respond number 4, ডংকেশ্বৰ respond number 4 আৰু প্ৰসন্ন respond number 3, R3 বুলি লিখিছে। এইখিনি লিখিব লাগিব, এড্ৰেছো লিখিব লাগিব। Okay. All right.
I will say that.
So Goswami, you had some difficulty. Why are you here now?
Just because I have another item left. You will not- Someone has, some respondent have died.
Lordship,
Item number?
item number 7, Lordship.
Yes.
In this case, Lordship, talk of settlement is going on, Lordship. Let the matter be set up.
Joint submission.
Don't have-
The learned counsel has jointly submitted that there is a talk for an amicable settlement outside the court. Full stop para. In view of such submission, comma, list this matter immediately after the summer vacations.
problem. First, we should not take time that time.
Obliged.
Mr. Sharma, which matter? 999, 099, 899, okay. 1009. Okay. 11, I think we can take.
Please, the Lordship. My lord, though, my lord, in this appeal, my lord, on 11 March 2020, my lord, to substantial question of progress frame, my lord. So, my lord, I have during this period, my lord, I have done for all these records and things, my lord. So, two more some substantial question of law, my lord. Yeah, I have got. So, I am arguing on this 2 points only, my lord.
You have
Yes.
to issue notice, give them copies. No, we can frame, but
Yes,
we have to give notice and they have to be prepared to answer on this.
Yes, of course, my lord.
And we have to also consider whether those would
My lord, already, my
constitute.
lord, this substantial question of law, my lord, already, my lord. Huh? My lord, first of all, my lord, the substantial question of frame petition, I will to read that.
Yes, page, which order?
11 March 2020.
11 March. Yes,
Yes.
two questions were
Yes.
framed.
The first one is, my lord, whether the respondent defendants have clearly admitted that the appellant's plaintiff are the owners of the Schedule A land and that the Schedule B land is the part of the Schedule A land and that they are tenant under the appellant's plaintiff. Number two, my lord, whether the learned first appellate court could have burdened the appellant to prove their ownership over the land described in Schedule A of the plain despite admission regarding ownership of the appellant over the state land, and as such, whether the finding on the point of determination of 1, 2, 3 are vitiated, being contrary to the Section 50th of the Evidence Act. Here, now, my lord, two more substantial question of law, though I have prepared newly, my lord, I'd like to read what the question I am willing to read.
Please hand over a copy.
Yes, my lord. Whether the learned Lord Appellate Court below was correct in refusing to grant consequential relief to the appellant plaintiff, particularly when issue number 1, 2 are decided in favor of the appellant plaintiff. Number two, my lord, whether the learned Lord Appellate Court below was correct in burdening the appellant plaintiff to prove their ownership over Schedule A land, which fact has already been admitted by the principal respondent defendant.
Two is one.
Yes, two. Yes,
is-
almost,
two is-
almost, my lord.
Yes, two is the same.
Two is one, my lord, almost. My lord, here, so far as, my lord, determine issue 1 and 2, my lord, or to have been recorded as the determination 3. 1, 2 already decided issue, my lord, in my favor.
Yeah, the new substantial question of law which you are trying to frame
My lord,
or assist the court by framing.
1 is
draft-
true, my lord. 1,
No, number two, which you have already framed.
yes.
It's already the same substantial question of law in already framed in the number 2. What is the difference?
My lord,
Your 2 and the question framed by this court as number 2, what is the difference?
my lord, why it is that the relying the substance kind of newly framed, my lord, it is little clear, my lord. So
No, what was the question framed? Whether the learned first appellate court,
first one, my lord,
yes, the second one.
whether the learned first appellate court could have burdened the appellant to prove their ownership over the land described in Schedule A of the plain despite admission regarding ownership of the appellant over the state land, and as such, whether the finding on point of determination 1, 2, 3 are vitiated, be contrary to Section 50. Sir, 2,
2 is exactly the same. Both 2 are same. What is your new one?
1, my lord, whether the learned was correct.
Was they correct in refusing to grant
Number 1, my lord, newly 1.
consequential relief?
Yes, though the issue 1, 2 are decided in favor of the appellant plaintiff, my lord. This is one only. The 2 is okay, my lord. So far as 1.
Mr. Sharma, what do you say? 2, I think there is no difference.
Yes, my
No,
lord.
no, my lord, the point is, the issue number 1 and 2 is in their favor. But the point is, the right title and interest. Now, see, if I ask for a title, I have to prove the title. Otherwise, court cannot. That is why, because this is third round loss. Initial, there is a decree, then appellate court decree, then second appeal. Second appeal has sent back the matter to decide one point. Now the court has decided that point. Now this third.
Are you contending that in the earlier round,
Yeah.
this court as a second appellate court had remanded only on one point?
Yes, to decide. Yes,
Only one
Lordship,
point.
please come.
Others have been settled.
Yeah,
Which was that point?
Lordship may come to page 43, para 10.
43.
Page 43.
Yes.
I have considered the submission advanced by the learned counsel of the parties and have also gone through the materials available on record. As noted above, the key controversy of the involved in this proceeding relates to the right of the plaintiff in respect of B schedule land, which claim was declined by the learned trial court on the ground that the state plot land was under the possession of the respondent, who is a non-evictable tenant. However, there is no finding recorded by the court below as to whether the defendant is in possession of the Schedule B land. The discrepancy in identity of the land as projected to the pleading of the parties prima facie goes to show that both the lands are not the same plot of land, all Alternatively, at least their description projected to the pleading are not correct. I am therefore in a view that the learned trial court was not correct in dismissing the plaintiff suit without ascertaining the said aspect of the matter. Although Mr. Majumdar has submitted that there are material available on record to establish the claim of the defendant, yet I am of the view that in exercise of the power under section 100 CPC, second appellate court would not invoke upon the trust recording any finding of fact for the first time. In such view of the matter, the court is left with no other alternative but to set aside the impugned decree dated so and so and remand the matter to the lower appellate court for a fresh question issue title. So that is the for that part, the court has remanded back. Now, Lordship, it is a third round. In the third round, Lordship, it is the page 32, para 17.
Thirty-two.
You want?
32.
Page 32, para 17.
Yes.
The Honorable Guwahati High Court wrote in para 10 of the judgment of RSA number so and so. This is he has quoted from that what I have read. Then in the next page, page 33, para 18.
Yes.
Para 18. The plaintiff has sought declaration that they have got right title.
The remand was to the first court or first appellate court?
First appellate.
Okay.
First appellate.
Oh, yes, please.
Para 18, page 33. That the plaintiff has sought declaration that they have got right title and interest over the B schedule land and for khas possession of the B schedule land. According to the plaintiff, Schedule B is a part of Schedule A land.
Yes.
The A schedule comprised of the land measuring 1 bigger 3 kata 19 lesa covered by curtain number 283, dag number 361 of village Mankasar so and so. The defendant has claimed that he has got royalty curtain number 315, dag number 3229 old and 2500 new under the plaintiff for 1 kata 19 lesa land, and B schedule land is part of that land. Neither party has disputed the identity of the suit land either before the trial court or before the appellate court. Rather, in para 8 of the WS, the defendant has written, as per the record, the plaintiff got 4 bigha, 1 kata 11 lesas situated in village Mankasar part 1, covered by curtain number so and so, and A schedule land is a part of the state curtain land. Defendant is a tenant of land measuring 1 kata 19 lesa out of the A schedule land measuring 1 bigger 3 kata 11 lesa, and the defendant has got royalty curtain under the plaintiff. So it is the quote and so it is clear from the WS that the defendant that the royalty curtain number 315 dag number so and so and so and so belonging to curtain number 283 of the plaintiff schedule A land. So I find that the suit land and the land over the defendant of the respondent has obtained royalty curtain in the same. So this is the finding. After the High Court sent back the matter. So Lordship have to see whether this finding is correct or not. Because earlier, all other points, the earlier second appellate court does not interfere. Second appellate court said, I am sending it back to look into this. And the appellate court has gone to all these points and the appellate court said the point for determination and come to the conclusion. And what is the suit? Now you can see the plaintiff is annexed. Now see for a moment come to the suit at page 6. Page 6.
Page 6.
Page 6 of the memo. It is the plaintiff.
Yes.
Lordship, it is a suit for declaration of khas position, valued at ₹100. Right? Now, Lordship, may please come to page 8. The prayer. The whole thing based on the pleading.
Page 8.
Page 8. Para 1. Prayer 1. Roman 1.
Yes.
For a declaration that the plaintiff have got right, title and interest over the scheduled land. Now the suit is for khas position. Now in the prayer, Roman 1 they said, for a declaration that the plaintiff has got right, title and interest over the scheduled land. And for a further declaration that the defendant is an unauthorized illegal occupier of the same, and as such the defendant is liable to be evicted from there. Now, if we ask for a right, title and interest, the basic thing is you have to give the title deed. You have to prove your title. The plaintiff have to prove his case. Otherwise, suppose I am not there. It's an expertise.
Then also it will not absolve the plaintiff from
Yes, that's the
discharging
point.
his burden. That is the
So
basic thing.
whether my here is there or not, it is immaterial.
Now, what was the materials which she had produced or
Nothing.
established?
Nothing. That
To
is like
prove
the
his
court has
title.
given the finding. There is no title deed. Lordship, Lordship may please come to page 22. That's
Mr.
my point,
Dekka,
Lordship.
as a plaintiff, you have to stand on your own foot.
Lordship, see
Okay.
for a moment what exhibit is there before the court.
Yes.
Lordship,
Yes.
page 22. Something unheard of, Lordship, in a title suit. Lordship has seen
Yes.
page 22,
Yes.
serial number 4, plaintiff exhibit nil. How the court will give, Lordship? There is nothing before the court. On the pleading, no one can give a title, at least. In a title suit, Lordship, there is not a single document, there is not a single exhibit, and the court will give the finding in favor of the plaintiff.
Yes, Mr. Dekka.
Also, I will. start my
Let
argument.
us go
Yes.
to the basics.
No,
You are praying for a declaration right title
No, my lord,
interest.
I will try to take your lordship first. The appellate court's finding. Kindly.
No, no. What was the relief you had sought for
Here, my lord.
in the plaint, in the suit?
Though my learned senior has thus read, my lord, that so far as I am concerned only on Schedule B. Schedule B. Though Schedule A, 1 bigger 3 kata 19 is not dispute, my lord.
Yes.
So for duct number 8283, my lord, kindly 30 and number 283, duct number 361 may be recorded, my lord. 361.
Okay.
And Schedule B, 30 feet into 50 feet. This is our case. It is inside the Schedule LN. This is our case, not that part. Schedule A, we're not disputing, my lord. Only you are concerned about Schedule B land. No, my lord. Written statement, page 11, para 13.
Now, why do you go to the?
My lord, why I am saying, my lord,
Now,
duct
why do
number-
you go to their case?
No, my lord.
Now,
Duct numbers,
first, let
they are
us.
saying, my lord, they
No,
are duct number directly 30 and duct number 315 for the last 35 years. I will come, my lord.
No, no.
If your lordship
let-
permits me to read the
no,
appellate court's
Mr.
finding
Dekka,
first, my
Mr.
lord.
Dekka, Mr. Dekka, let us ignore the written statement. Let us go to
Yes,
worst case.
yes, my lord.
That it has not been contested at all.
My lord,
You have to stand in your own foot.
my lord.
You just show a single document from where you can at least make
My
out a
lord,
case
it is
that you have a title over
Since,
the
my
land.
lord, the second appellate case, I have to argue only on the law point legal issue, my lord. Since, my lord, that first appellate court, my lord, that period so far as facts as well as law is discussed, my lord. So what is the law value? It is the question of law involved here. I have to, my submission is very limited on the legal issue only, my lord. So,
You-
lordship,
you-
kindly allow me to satisfy your lordship on the legal point, my lord.
No, Mr. Dekka, you're absolutely correct that our role is very limited.
Sir,
And
What
but
document I agree with that? What I document I not agree with
your
that duct letter, my lord.
submission will be counterproductive. It will go against you.
Well,
If
lordship,
we
my lord.
limit, if we limit our jurisdiction on what we are supposed to do in a second appeal, you have to first make out a case. You're the plaintiff.
Lordship, page 29 of the appellate court's finding, my lord. I will satisfy your lord.
29.
I will try. Yes.
29.
Yes, my lord.
Yes,
Of the appellate court. My lord.
yes. Additional issues.
Yes, my lord. From para 10, I will read me. The learned trial court has framed the following issues. Number one, whether the defendants acquired right status under the plaintiff in respect of the suit land. Whether the defendant is evictable, whether the plaintiff is entitled to get any relief. Though in the plaintiff, I made a prayer for right title interest, but not right on the issue of right title interest, no issue framed by the trial court. Next additional issue deemed fit by the appellate court, it is that is the suit not properly the number, my lord, the point for determination. Number one,
Yes.
whether the plaintiff appellants had been able to prove that they are the owner of the Schedule A schedule land. Number two, whether the plaintiff appellant had been able to prove that B schedule land is a part of the A schedule land. Number three, my lord, whether the suit land and the land over which the defendant respondent has obtained righty khatian is the same land. Now, my lord, 13, 1, 2, and 2. The plaintiff appellant's plea is very simple, that they are the owner of the A schedule land. The defendant had encroached the B schedule land, which is the part of the A schedule land. The plaintiff had not submitted any document showing their ownership over the A schedule land. The defendant has admitted this fact that the plaintiffs are the owner of the A schedule land. Admitted fact need not be proved. Regarding the facts of disposition, the PW2 Pareshandra Shaha said in his cross-examination that the defendant is there in the suit land and since last four years and so, prior to which he was in an adjacent plot of construction at Chapra, where he was about 10-15 years. The defendant carried on firewood business from the suit land. The Ajit Bandhu came about for a month of construction of the Pakka house. PW3 Kamakhya Sharan Mohanto said in his examination in chief that defendant was a permissive possessor and was allowed to stay in the room, prior to which the defendant was a tenant under the plaintiff. The defendant forcibly dispossessed about 45 into 30 feet of the plaintiff's land in absence of plaintiff and continued dispossess despite resistance of the plaintiff and now has constructed a Pakka house there. In cross-examination, PW3 stated the defendant is here in the Mankasar since last 40 years or so. The defendant is there in the disputed land for the about 8 to 10 years and he used to sell firewood in his land business. From the plaintiff's side evidence, it has come to light from the evidence of PW3 that the plaintiff allowed the defendant to stay over the student as permissive possessor, which fact is a new one. It has also come to light from the evidence of PW3 that the defendant was a tenant of the plaintiffs, though same is denied by the plaintiff. The fact of the disposition of plaintiff by the defendant is not denied by the defendant's side. The DW1 Nimai Bhattacharya defendant has not said in the year which he has settled the plaintiff as a tenant. DW1 has stated in detail in his examination chief about reservice settlement operation 1991 of the Mankasar town area and the getting righty khatian in his name under the plaintiff. DW1 in his cross-examination said that earlier he was in Bangladesh and came to India and stayed in the house of Nishikanta Burman for 5 years. The plaintiff is not his relative, but of the same community, and they came to in contact as such the plaintiff allowed him to stay in his house temporarily. At the time, the plaintiff was surviving as the teacher in the Dhubri, and his other two brothers went at the Tura, and there was his aged mother in his house. The defendant is still residing there. There was no written agreement between him, defendant, and the Master Babu, plaintiff. The said the land of the plaintiff, but the defendant constructed his house. The suit land is in the town area. The suit land is a homestead land. The defendant has not paid any money to Master Babu plaintiff, nor any salami. His land is 12 cubic, 10 cubic. He has the RCC house. He has not obtained any permission from the town committee or any objection from the plaintiff. It is clear from the evidence of defendant that he came to India from Bangladesh and was allowed to stay in the plaintiff's house temporarily. So the defendant originally hailed from Bangladesh. The defendant has not said clearly in which year he came to India from Bangladesh. The defendant's side has not examined any official from the Revenue Department office to prove that the fact that any resettlement of the Mankasar town area was conducted in 1991, a righty khatian has in fact been issued in his name. When the defendant has said that he has come from Bangladesh, it has come more important to see in which year he has come to India and whether he has obtained Indian citizenship or not before claiming any right about the lands of Assam or elsewhere in India, because the land rights are available only to the Indian citizen. The defendants claim that he was first allowed to stay temporarily and subsequently he was settled as tenant by the plaintiff. Admittedly, there is no written agreement between the plaintiff and the defendant. Hence, strict proof required. The land holding certificate does not mean that the person is rightfully having the said land. The land holding certificate the revenue received simply implying possession. But one has to justify his position. It is not sufficient if somebody has got Rayati Khatian, that means he has rightfully got the same. He has to show that he was rightfully got the Rayati Khatian. The documents are not manufactured. In this case, there is no written agreement of any tenancy between the plaintiff and the defendant. Second, the defendant has come from Bangladesh and he has not shown in the year in which year he came from Bangladesh. He has also not shown that he has got Indian citizenship. The defendant has not proved his inclusion in the Kacha Patta as riot in the resettlement 1991 by examining by settlement officer. For the above reason, I find that defendant respondent had not been able to prove that he was a tenant under the plaintiff. So issue number 1 is decided in negative in favor of the plaintiff and against the defendant. And as I find, the defendant has failed to prove that he is a tenant under the plaintiff appellant. I find that defendant is evictable. So issue number 2 is decided in favor, affirmative in favor of the plaintiff and against the defendant. So far as both the issue that he failed to riot, he failed, and so far as although appellate court held that he is a evictable tenant, my lord, it is there. Then, my lord, in paragraph 17, though my learned seniors read the High Court's, Honorable High Court's observation here, my lord, that this Honorable High Court set aside all the findings. So therefore, appellate court has discussed all the issues, and ultimately, my lord, this issue number, my lord, that whether the defendant equal righty status under the plaintiff respect of the suit, that issue decided in favor of plaintiff. And number 2, whether the defendant is available, also learned to appellate court that he is evictable.
Yes.
So after all these things, my lord, is proved, then when only question of then when the issue number 3, whether the plaintiff is entitled to get in, thereafter the facts recorded by the authority, my lord, contradictory, my lord. Since I am there is no dispute there, and admitted that I am the owner of the land. Since on admission on the part of the defendant, I am the owner. So section 58 evidences is in favor, my lord. So admitted fact need not be proved, my lord. So my humble submission, my lord, the appellate court findings, my lord, the absolutely perverse, my lord, and it is true that when my position, when my own legal right is abridged by the defendant, my lord, though it is exhibited petitioner that he was dispossessed, my lord, under that still he has not exhibited, but all the appellate court has decided all the issue categorically decided issue number main issue, right, whether he's the right or not, whether defendant
Yes.
the prime issues already decided in my favor, my lord. Despite this, my lord, finally, my lord, the rest paragraph, it is contradictory.
Let us have a look at 58.
Yes, my lord.
In fact, it need to be proved in which where three the parties that were which
So in support of the section 50 of the law, I have to rely on decision of the Honorable Apex Court, my lord.
what were exhibits, Mr. Sharma? This you had relied upon. You have shown a page at page 22 regarding the exhibits of the respective parties.
Yes.
The defendants did not have any. The plaintiffs did not have any exhibit. That's okay. What there were 4 or 5 exhibits by you. What are those
There
exhibits?
is exhibit 4, then exhibit 4. There is all
What
my
are these?
exhibits are there, Khatian and all.
Now, did you take it to recall the 71 Act, Temporary Settled Act?
Yes.
You obtained orders under 23, Section 23. Where are those?
It is the exhibit 4. Exhibit 4.
Any discussion on those?
Yes, Lordship, my only on that Lordship, it is all right. What my learned friend is are good, and the that on admission, the court can give it.
Hmm.
Now, Lordship, court come to a conclusion
Hmm.
that I am a Bangladeshi.
Hmm.
Land law, it will be very difficult in a civil case. Now, tomorrow, what the people will do? Bring some person to come and admit my case, and court will give a decree. If Bangladeshi will come, the court has given a finding that he is Bangladeshi. My client, regarding my client, the court, a civil court has said he is Bangladeshi. He has come, but at the same time, the same court has said, now this Bangladeshi has admitted that he is the owner. Court will give the decree on that, on admission. It's something.
But it has to be decided,
Well,
it is a list between the parties. We have to decide between the parties. We will not go into the other aspects.
Yes, yes, but the point is, Lordship, the plaintiff
He
have to
wants your
prove his
eviction.
own case.
He wants,
Plaintiff, that he is the owner, you have to prove his own case. My admission will not do. My Khatian is there. It's all right, but on my admission, the court cannot
see,
give a
to
decree.
to the extent of a declaration of his right title interest, if the court has not given any such declaration,
Yes.
you are right in contending. But what about the other aspects?
What is?
Other aspects of your
Now,
eviction?
there is no counterclaim. The court cannot give in my favor. I have not filed any counterclaim.
No. His claim to evict you, the court holding that you are.
If we cannot prove that he is the owner, court cannot.
No, if you are an evictable tenant and there is no.
Then you have to prove that his title.
No, and there is no challenge to that finding
Whose finding?
that you are an evictable tenant.
Evictable tenant, yes, but at the same time, the court come to a conclusion. Why I will challenge? Court come to a conclusion that he has not proved this case. He has no title. Why I will go to file?
No, that is why he is before us.
Yes.
That is why he is before us. The
Yes,
correctness.
then the court have to see what is his proof, what he has exhibited before the trial court for his claim.
Then what is the meaning of section 58? The
58
substantive
Lordship
question of-
at this. Then Lordship have to see the court has come to a conclusion that the person who has admitted is a Bangladeshi. He is not a citizen of India.
Those are not aspect before us.
So yes, this
not-
court. So a civil court cannot decide all this.
We are not on the what the status, whether it's a Bangladeshi or
This court
national-
cannot decide.
we are
So
not
if-
going to the nationality aspect.
All
We are only on the
that-
aspect of a lease between
Even
two parties.
even on admission, even
Yes.
in a collision suit, Lordship. Let's think of a collision suit. That I filed a suit against the
No, is the relief he is seeking any against a third party or against you? The collusion suit, the aspect of
Title-
collusion will
title
come.
is against not against me.
Title has not been declared.
No, not been declared. That is why suit is
No,
not
the
being-
aspect of collusion will come when he wants to take an undue benefit qua a third party.
Yes,
Now it is a lease between you.
yes,
Whether you collude or not, it's ultimately your eviction he is seeking.
yes. Then
are
he have to prove-
contesting.
Then he have to prove.
You are contesting the suit as well as you are admitting that there is no
Yes,
denial
then
regarding.
Lordship, that I have proved my case. My exhibits are there that I am a tenant. Khatian, my Khatian is there. And then the 54 of the Act, procedure for ejectment, all these things are there in the Act. That he has not followed. So in a civil suit, first he have to prove his own title. If he fail to prove, matter ends there. Because I have exhibited my document.
Let us see the plaint again.
Yes,
Page 6.
yes, let's see. So-and-so versus so-and-so, suit for declaration of khas possession. It is a suit for declaration of khas possession. Plaintiff is so-and-so, that the plaintiff are the owner of a homesteaded land measuring 1 bighah so-and-so, so-and-so. That the plaintiff has got their residential house in the said land. That the defendant, taking the opportunity of the absence of the plaintiff, has illegally entered into a portion of the AC2 land, disposes the plaintiff from the same in the early part of April 1997, which has been described fully in Schedule B below, which is hereinafter called the suit plan of the suit. So suit plan is B.
Let us see your the order which was passed in section 20, under section 23 of the 71 Act. Is there any order in your favor?
No, that is not with me.
Then what did,
Two exhibit?
what are those exhibits then?
It
How
is
did you,
Khatian.
how was Khatian issued to you? Under what capacity?
The order was not exhibited. Khatian was there.
Now,
And the-
Khatian issued under what is the strength
Or
of the
one
Khatian?
order is there. Mati Thokar Praman Patra and all that type of thing is, and the Khazana, the payment, rent and etc. I have all these documents.
But
that-
if you have not instituted a proceeding under section 23
No.
of this Temporary Settled Areas Act of
But the
1971,
Khatian is issued, that Khatian was proved. That order is not there. What is not there before the trial court lawsuit in the second appeal, I cannot prove. But even if the order is, I can. The exhibit,
then the issues which he is trying to hesitate, those will have to be looked into.
then lawsuit did. All right, lawsuit will look into that, but then lawsuit, the law is very clear on that he have to prove his, yeah. If it is a title suit lawsuit, because his declaration is page 8, is something for a declaration that the
Yes,
plaintiff
yes,
has got.
yes, Mr. Decker. Please address. Will hear properly? Okay. You are the plaintiff.
Yes, ma'am.
Appellant is the plaintiff.
Yes, ma'am.
One appellant.
My lord, initially my brothers were here, my lord, here, PW3 before this court.
One appellant.
Yeah.
One of the plaintiffs.
Yes.
Suit for, we have seen for
Yes,
declaration of khas position.
first position.
Declaration means what? Confirmation or recovery or what? What is the meaning of declaration? Declaration of right title interest, we understand. What is declaration of khas position? Confirmation? Or
My lord.
recovery?
But it will not take it up prepare.
It was in position of whom? Your position or their position?
Our position is law. And
Huh?
this possess this particular portion of piece of land.
This possess.
This
So
possess.
your recovery of position.
Yes,
Exact expression should have been recovery of position.
recovery of position.
Doesn't matter. Okay. What was your case?
But in this case, my lord, admittedly we are the owner of the land. There is no dispute, my lord. Since
Of
this
a,
claiming-
of a scheduled land.
Yes, the land, my lord. Since this defendant claiming that I am the plaintiff's tenant, my lord. Yes,
Huh?
I'm the defendant is claiming is a tenant of
Now you are the owner of a scheduled
land.
land. Defendant claimed that they are tenants.
Tenants.
How many defendants?
Defendants, my lord, one, Nimai.
Okay,
Initially, he Nimai Chandra, but after legal heirs come in,
okay, that he was a tenant.
tenant. He's claiming as tenant, my lord.
Okay, then
And yeah, my lord, we are claiming our right title. So
tenant means a riot or what?
he's claiming, my lord, at a tenant, my lord.
Not a riot.
Tenant. That's why his written statement,
Okay.
paragraph 5, that defendant is a tenant under plaintiff.
Okay. Para 5 of WS.
Yes, my lord.
Okay, then what had happened?
Then, my lord, in plaint, my lord, in the schedule, my lord, the land measuring 1 bigger schedule 81 bigger 3 cutter 19 lesser covered by Khatian number 283 and duct number 361.
Schedule A.
Schedule A.
Khatian number?
Khatian number 283 and duct number 361.
361.
Yes, my lord.
Hmm.
In the village Mankachar part 1.
Okay.
Okay, my lord. Now, my lord, schedule B, where recovery of first position, my lord, that is only 3 feet into 50 feet. It is, my lord, as per 9 null. My lord, that's the very small.
Schedule B is how much?
30 feet into 50 feet.
30 feet into 50 feet. Okay.
Now, my lord, in WS, my lord,
You want recovery of Schedule B area,
Schedule area.
which is a part of Schedule A area.
Area.
Okay.
So, in WS, my lord, in paragraph 5, they admitted their tenant under plaintiff and number paragraph 8, my lord.
Which para?
Para 8 of WS.
Admission.
Yes, my lord.
Page.
Page 10.
Para 8.
Yes. That regard statement, there are one plaintiff. The defendant begs to state as per the land record, plaintiff have got 4.1.11 leases situated in village Mount Katapat, pattern number 283 and civil land is the part of the said civil land. Now, my lord, and defendant is a tenant of land measuring 1 cut of 14 letter out of a civil land measuring 1,311 letters, and defendant has got Rayati Khatian under the plaintiffs and possessing the same thereon constructing dwelling house in his family last 35 years. So now I like to take your lordship, para 13 of the written statement. Page 11, para 13. Para 11. One place they have said they are tenant, paragraph 5. In para 8, the last part they have said the Rayati Khatian. In para 13 now, the duck number and the Khatian number.
Yes.
In this guard statement, para 6 of the plain defendant begs to state that the land mentioned in Schedule B is the part of defendant tenanted land measuring 1 kata 19 letters covered by my lord. Kindly mark it. Rayati Khatian 315 here, not 316. Rayati Khatian
Just
315.
the Schedule B is what? How much?
Yeah, as per the
1K or 19L.
yes, lord. 1K 19L.
Under Rayati Khatian?
315. Under Rayati Khatian 315 dark number, my lord.
Or Dag number? 315
Old
Dag number.
3229 and new 2500.
Rayati Khatian 315.
Yes.
Dag number?
Old 3229 and new 2500. And they're claiming that living their land since
35 years.
35 years. Now, my lord, para 15, finally. The defendant is possessing and living on the Schedule B land, no claim on it, Schedule B land by his own tenancy right. Hence, the plaintiff has got no right to file eviction case against the defendant, and tenant has not evictable as per law. That is the last part. That means, my lord, is concerned the Schedule B land is he having tenancy right, my lord. It is very important.
Okay.
So far as Schedule A is concerned, my lord, we are very limited portions of the land which has been within this possessed. It will be only very concerned of that, not entire A schedule land, my lord. So entire A schedule, he cannot raise any question, my lord. That means we are the own, admittedly, we are absolute owner of the A schedule land. Now, my lord, what the finding of the trial court, first the trial court, my lord. Okay, kindly have a look on page 15.
1-5.
Only page 15, my lord.
1-5.
Yes, my lord. It is titled 17 of 2098, 98 suit, my lord.
Just a minute, please. This is, what is the date of the judgment?
Yes, my lord.
Is it for
Yes, my lord.
1812? Is it on the 24th of December?
Yes, my lord.
03, judgment of Civil Judge Junior
Civil Judge
Division.
Junior Division, number 1, Thupuri.
Okay.
In the judgment, my lord, the facts recorded, my lord. 3 issues framed at page 16.
Yes.
The first one, that defendant acquired variety status under plaintiff in respect of the suit land. Number 2, whether defendant is evictable. Number 3, whether plaintiff is entitled to get any relief in court, is this suit not properly valued? This is 4 issues framed.
4 issues.
4 issues, my lord. Whether the plaintiff having a right title or over civil land is the issue here, my lord. Now, decision, decision and reasons, my lord. Your lordship permit me, can I read, my lord?
Just a minute, please.
Yes.
Yes, please, which part you want to read?
Page 17, issue number 1, my lord.
Yes.
That is, whether defendant acquired right status. This is the question here, which was framed in order to determine whether defendant acquired right status under the plaintiff in respect of the suit plan. It is found that the case of the plaintiff is that the defendant illegally entered into the portion of A schedule land and dispossessed the plaintiff from the same in the early part of the April 1997, which land is described in Schedule B schedule of the plaintiff. The defendant, on the other hand, in the WS stated that the defendant has got priority khatian under the plaintiffs and possessing and living thereon by construction dwelling house with his family members since last 35 years. The PW1 has stated in his deposition that defendant encroached upon the land measuring 50 feet into 30 feet and started construction despite his protest. In his cross-examination, the PW1 admitted that defendants acquired Kachapata in their khatian and that the suit land was not surveyed, but the BCD land was quoted on an approximate idea. The PW1 further deposed that the suit land measured 1 bigger 14 kata approximately in dock number 361, kata number 283. But in his cross-examination, he stated that entire land, 1 bigger 4 kata anti-lesser land is under 2 ducts belonging to duct number 723 and 361. But in his plaint, he has mentioned only the 1 duct. The PW1 further deposed that the defendant is now a part-time priest. The PW2 stated in his deposition that the defendant deals in firewood and that the suit land is covered by duct number 361. And in his cross-examination, he stated that he does not know whether the defendants are there in the disputed land since the last 35 years, and that during the disposition and the construction of the defendant, the plaintiff's sister was there, who is an old woman, and as such, she did not resist. PW3 stated in his deposition that about 4 years back, the defendant was a primitive possession and allowed to stay in one room, prior to which the defendant was a tenant under the plaintiffs, and the defendant forcibly disposed about 40 feet to 30 feet of the plaintiff's land in absence of plaintiff and continued disposition despite resistance from the plaintiff, and now has constructed a pakka house there. In his cross-examination, the PW3 stated that he cannot say whether the suit land was settled with the defendant. On the other hand, the DW1 has stated in his deposition that the suit land is covered by khatian number 283 and duct number 361, and that, my lord, this is important line. In W, that he stated in his deposition that the suit land is covered by khatian number 283. My lord. In the WS, also you will find a different, my lord. 283 and duct number 361. And that there are 4 bighas, 1 kata 11 latches land in the said khatian, and the air siddle land is a part of the said khatian, and that is a tenant land measuring 1 kata 19 lessa of air siddle land under the plaintiff, and have been possessing the tenanted land since the last 35 years, that the B siddle land is a part of this tenanted land, my lord. And DW1 further stated that he got right khatian of his tenanted land measuring 1 kata 19 lessas under the plaintiffs, and the said khatian was marked as Exhibit Co. And the land law, that means, my lord, Exhibit Co is the khatian measuring 1 kata 19 lessas, the having khatian, my lord, Exhibit Co. And the land holding certificate was marked as Exhibit Co. Now, DW1 also stated that he paid land revenue for the entire 4 bigha 1 kata 11 lechas of land, and the rent received were exhibited as Exhibit Go 1 and Go 2. In his cross-examination, DW1 stated that there was no written agreement between him and the plaintiff. So he's claiming as a tenant, but there is no agreement with the plaintiff, my lord. And the land is plaintiff's, but he constructed his house. So no agreement, but he constructed house. And the suit land is in town area, and that he has not paid any money to the plaintiff nor any salami. This is something. DW1 himself admitted this. There is no agreement, no money paid to the plaintiff, but he constructed house there in the town area. Now, DW stated that The defendant is a tenant for 1 kata 19 lestas of land and possessing the same since the last 35 years. But in his cross-examination, stated that he cannot say what is written in the affidavit as it was not explained to him, my lord. That means, my lord, DW1 is not aware that he just simply put signed and he is not
DW2.
DW2, my lord. So he himself he is not aware what is written in that DW. So his evidence may not be considered, my lord. So DW stated that defendant is a tenant, stated he cannot say what is written in the affidavit as it was not explained to him, and hence the defendant or two cannot be relied upon. Okay. DW3 has started in his deposition that the defendant is living in the suit land as tenant under the plaintiff since the last 35 years, and the B schedule land is a part of the defendant's tenanted land, and that he knows that the boundaries of the suit land. But in his cross-examination, he stated that he does not know how the plaintiff came into the suit land. Now, therefore, upon consideration of the entire evidence in the case record, it is found that the exhibit co, which is a rarity Khatian in favor of the defendant, was exhibited without any objection, and moreover, the plaintiff had not stated anything in the plaint about the defendant being the tenant under him, and further, the learned counsel for defendant in the course of his argument submitted that the learned appellate court in Miss Appeal number 20 also pleased to hold the view the defendant is a right for the suit land. The plaintiffs have neither stated that the exhibit co was obtained fraudulently nor paid for cancellation of the same, and considering all the facts and circumstances, I am of the opinion that defendant is a riot under the plaintiff and with respect of the suit land, and that is the issue is in favor of the defendant, and so this issue is therefore decided in favor of the defendant and against the plaintiff. Number 2, my lord, is regard to the issue number 2, which was framed in order to determine whether defendant is evictable. It is found that the defendant is a riot under the plaintiffs with respect to the suit land as determined by the settlement of the issue number 1, that the plaintiffs have failed to establish the fact that the defendant has illegally entered into the suit land by dispossessing the plaintiff thereon, and considering all the facts and circumstances, I am of the opinion that this issue is in favor of the defendant and against the plaintiff, and the same is decided accordingly. Finally, issue number 4, my lord here. As regards the issue number 4, which was framed in order to determine whether suit is not properly valued, it is found that the perusal of the case record that the plaintiff have filed this suit for declaration and class position valued as 100, and the defendant is in WS took the plea that the suit is not properly valued as the subject matter of the suit is not less than 20,000. The plaintiff did not adduce any evidence with respect to this issue, but a DW1 stated in his examination in chief that the present value of the suit land will not be less than 20,000, and also in his cross-examination, he stated the suit land will be valued at 20,000, which is not challenged by the learned counsel for the plaintiff. Thus, from the evidence to record, it's apparent that this suit has not been valued properly, and as such, this issue is also against the plaintiff. Issue number 3, which is with respect of the relief to the plaintiff may be entitled to this suit, is found that plaintiff have failed to establish the fact that the defendant is an unauthorized illegal occupier of the suit land. The plaintiffs have failed to establish their case as in apparent the above issues. As such, the plaintiff cannot be entitled to any decree or relief. Therefore, this issue found against the plaintiff and the same decided accordingly. Ultimate, the trial court decided the issue, my lord, and then we prefer the appeal, and appellate court find earlier appellate court decided appreciated the findings of trial court, which challenged before the court and filed in second appeal, and second appellate court, my lord, in the high court, my lord. Before taking to the impinged judgment, my lord, I like to draw your lordship kind attention page 40 of the second this honorable court's order in earlier second appeal at page 40, my lord.
Yes.
And I'm well, paragraph 7, page 40.
42.
Yes, my lord. That's the text recorded, page 40, paragraph 7.
The order dated 16/8,
High Court, this honorable court.
16/8,
Yes, my lord.
18.
16/8.
Yes.
At the outset, the learned counsel for the appellant has invited the attention of this court to the pleadings in the claim as well as an statement which goes to show that B-schedule land claimed by the plaintiff is covered by Khatian number 280 of block number 361 of the village Mankasar Part 1 under Mankasar Circle, whereas the respondent defendant has claimed tenancy right over the land based on right Khatian number 315 involving block number 3229 all and this. As such, there is an apparent discrepancy in the description of the land, land as well as the land claimed by the defendant. Mr. Choncho Learned Counsel Appellant submits that since the courts below have dismissed the plaintiff's suit holding that defendant was not evictable tenant, it was incumbent upon the learned court below to record a finding of facts as to the true identity of the land claimed to have to be under occupation of the defendant. Since no such finding of the fact has been recorded by the learned court below, hence, according to the counsel, the finding with regard to issue number 1 is the purpose and cause for reconsideration. So, counsel for the appearing for respondent has clearly submitted that on the face of the record of this case, description of the suit land in Schedule B land does not tally with the variety Khatian relied by the defendant. And to such extent, it was necessary to record a finding of facts as to whether both the lands are different or same plot of land. The learned counsel, however, submits that there are materials available on record to show that both the plots of land are one and the same. I have considered the submission advanced by the learned counsel for the parties and have also done so the materials available on record. As noted above, the key controversy involved in this proceeding related to the right of the plaintiffs in the respect of B-schedule land. This claim was declined by the learned trial court on the ground that said plot of land was under possession of the respondent, who is not an evictable tenant. However, there is no finding recorded by the courts below as to whether defendant is in possession of the Schedule B land. The discrepancy in the identity of the land as projected through the pleadings of the parties prima facie goes to show that both the lands are not the same plot of land, or alternatively, at least their description projected through the pleadings are not correct. I am therefore of the view that learned courts below was not correct in dismissing the plaintiff's suit without ascertaining the said aspect of the matter. Although Mr. Choncho has submitted that there are materials available on record to establish the claim of the defendant, yet I am of the view that in exercise of the power under Section 100 CPC, a second appellate court would not embark upon task of recording any finding of fact for the first time. In such view of the matter, this court is left with no other alternative but to set aside the impugned decree that is essential and remanded the matter to the Lord Appellate Court for a fresh decision of the title. Accordingly, considering the suit of the 1998, Lord Appellate Court is requested to make an endeavor to dispose of the appeal in accordance with law within a period of century. Ultimately, the Appellate Court, at page 26, its findings. That is on 24 June 2019.
Just a minute. Okay. Yes.
Okay, page 27.
After the remand.
Yes. After remand, the appellant's plaintiff filed this appeal on the following grounds. I will not read all the lord.
Just a minute. Yes.
Yeah, my lord. 8 grounds they have taken in appeal. Only I will read 6, 7, and 8. 3.
Yes.
The defendant seeks in the written statement stated that he is the tenant of the land measuring 1 quarter 19 less under the plaintiff for the last 35 years. The plaintiff denied the same. Number 7. The learned trial court ought to have decided that Hatia revenue record does not create or extinguish any right, title, interest of any land. This question we raised. And number 8, the learned trial court ought to have held that the mere possession is not sufficient for mutation of name of a person in possession, and also ought to have held that the revenue authority had no power or jurisdiction to mutate the name of the defendant in absence of any right in the suit land. This exhibit is the bogus one and not believable. These 3 grounds, my lord, we have taken before the appellate court. That's mainly, my lord, 7, 8, 6, 7, 8. 7, 8.
Now, what about the main issue regarding the identification of the land?
Lord.
Description given by you were not telling with the descriptions given by them.
That's
So-
important difference, my lord.
Khatian is also different.
Different.
Dag is on that issue. On that
This
issue, what
honorable
was the,
court has remanded that.
what is the finding of the first appellate court?
My lord, my lord, that they appellate court finding paragraph 17 name being judgment,
Page?
page 32.
Yes.
So previous paragraphs though decided all the issues in favor of the present appellant in 17 minutes.
Yes, 17, the High Court's
Order the findings below page 18,
Mm.
para 18, page 33. As per the High Court's remand. Yeah.
yes.
The plaintiffs have showed declaration that they have got right, title, interest over B schedule land and for first possession of B schedule land. According to plaintiffs, the schedule B is the part of A schedule land.
Mm.
The schedule A comprises of land measuring 1 meter 3 quarter 19 lessons covered by Khatian number 283 of Dock number 361, village Manchester Circle. The defendant has claimed that he has got writing Khatian 315 Dock number Sencho under the plaintiff for 1 quarter 19 lesson land, and the B schedule land is the part of the land. And look, this is the difference.
Hmm.
Neither party has disputed the identity of the suit land, either before the trial court or before the first appellate court. Rather, in paragraph 8 of the WS, the defendant has written that as per land records, the plaintiffs have got 4111 letters situated in village Manchester Part 1 covered by Khatian number 283, and the schedule land is a part of the Khatian land. Defendant is a tenant of the land measuring 1 kata 19 letters out of the A schedule land measuring 1, 3 and 11 letters, and defendant has got right Khatian under the plaintiff. And so it is clear from the WS, the defendant, that right Khatian number 315 Dock number Sencho belongs to the Khatian number 283 of the plaintiff's A schedule land. So I find that suit land and the land over the which the defendant respondent has obtained right Khatian is the same land. So right is Khatian, my lord, just bare relying the WS paragraph 18, my lord, it is declared it is the part of the split. Next, my lord, 19. The
Mr.
plaintiff,
Sharma, how is this possible? Dark numbers are different, right? Khatian is different.
No. Dock number it is the old and new, everything is there in the
No, the Righty Khatian is one is 315, one is
Dock number
283.
3229 and Notun Dock is 225
Okay, to there and the
and the Khatian is 300.
as per the plaintiff, the dark number is 361. 61.
I don't know, Lotip. Where from I'll come to see? There is no document. His statement is there.
No. See,
There is no document. I do not know.
The-
Because
the-
my director Khatian, his name is there.
the reason why the remand was made was
Yes.
because there was a discrepancy in the description of the land.
Yes.
He says that I am the owner of a scheduled land,
Yes.
out of which one part has been is under your possession illegally.
Yes.
So he has prayed for your eviction.
Yes.
In simple terms,
Yes.
you say, and he has said that this is the description of my land,
Yes.
out of which B scheduled land is a part of A scheduled land,
Yes.
and my A scheduled land is this is the dark
This is
number,
the
this is
pleading.
the
Yes.
Khatian number.
This is the pleading.
So your case is that you are also a Khatian holder.
Yes.
Your Khatian numbers are so and so, no problem with that. But your dark numbers are also different. You have two dark numbers, old and new. Old may be different than new, definitely. But it has to have some connection with dark number 361. Your Khatian is for another plot of land.
Allah. Lordship. So that is what I am saying, Lordship. If there is there's some difference and yeah, then you have to prove by document that this is my land. This is my number. My Khatian is 1 katha, 19 lesser. Where is his document to show that this is not the land, this is the land, this is my number, this is my title deed, this is my patta. Where is that? I said in my year, his name is there. My document is exhibited. Without objection. Without objection. There is no cross-examination on that. Secondly, Lordship has come to a
But
finding.
in absence
Lordship,
of-
there is a finding that
No,
I am a tenant.
In absence of a cross objection by you
Hmm?
on this finding,
Yes.
can you, as a respondent, can you raise this now?
No. Lordship, when he said that he is not the, he has no right, title and interest, why I'll file a appeal against that? My Khatian has not been cancelled. I'll continue with my Khatian, I'm happy. Because Lordship can see, Lordship, after the
No, findings at
Lordship, Lordship
paragraph
has said-
18.
Lordship is very correct.
Findings at paragraph 18 is not, in spite of the remand, what the court has understood and made the remand.
Because there is no document on his part, where from the court will see what is his land and ye. He has not proved that this is my land. Because in a title suit, because he had to prove his title, he has to prove his document. What is that?
Defendant is a tenant of
Then Lordship,
land
he has not, he has read paragraph 18. Lordship, may please come to paragraph 19 at page 33. Let us read paragraph 19 again. The plaintiff claimed that they are the owner of A schedule and the B schedule in part of the A schedule land. The plaintiff said the plaintiff side had not exhibited any document regarding their ownership over the A schedule land. The admission of the defendant that the plaintiff are the owner of the land over which he has obtained tenancy Khatian does not itself make the plaintiff owner of the A schedule land. The plaintiff must have produced an exhibited document showing that they are in fact the owner of the A schedule land. Had there been any revenue record before this court showing the ownership of the plaintiff over the A schedule land, this court would have compared what the Lordship has said. Whether the land over which the defendant claimed to have obtained the Rayati Khatian is same as the B schedule land or not, because there he have to compare being a revenue court, being a civil court. Where he will compare? From where? From which document? Now says that it is not. Where he will compare? He has come to a finding in paragraph 19. Why he said that? Paragraph 18 is all right, but the paragraph 19 he has explained why he is not under position. And then Lordship has said that he is a Rayati Khatian. It is there. So that is, if that is there, Lordship, in the paragraph 18 last line, I find that the suit land and the land over which the defendant respondent has obtained the Rayati Khatian is the same land. Right? Lordship, if the Rayati Khatian is there, Rayati Khatian is an official act, 114 is there. There is no cross, nothing on that. If the Rayati Khatian is there, now Lordship has said that the act, now Lordship may please come to the act, section 54. Let us see, because we are in a second appeal 100. Second bit of consent.
Yes.
Lordship, Lordship, may please come to section 54.
Yes.
Procedure for ejectment. No tenant shall be ejected from his holding except in execution of an ejectment decree passed by a competent civil court, and the relevant provisions of the Civil Procedure Code 1999 shall apply to such proceeding. Now, 2. No suit for ejectment of a tenant on the ground mentioned in section 51, 1, 2, A and B shall be entertained unless the landlord has first served a notice on the tenant requiring him to remedy or to pay compensation for the misuse or the breach complaint of an tenant has failed to comply with it within 1 month of receipt of the notice. Then Lordship may please come to 51. There are the ground of ejectment. An occupancy tenant shall not be ejected by his landlord from his holding except in execution of a decree for ejectment passed on the ground that he has used that the land comprises a holding in a manner which render it unfit for the purpose of the tenancy. Now, any tenant not being an occupancy tenant shall not be ejected from the land of his tenancy except in execution of a decree for ejectment passed of any one or more polling ground that he has used the land comprised in the holding in the manner which is rendered unfit for the purpose of the tenancy, that he has broken the condition of tenancy consistent in the so these are the ground. Lordship. 51 is the ground. 54, there is a specific way that the notice is a must. Then only you can file a suit. That 1 month notice. And notice you have to give the ground. And the tenant fail. If the Khatian owner fail to give the reply and all that, then only you can file the suit. Now on that, Lordship, there is a direct decision of this honorable
No,
court.
no, those are settled. There is no dispute with this.
On, but if just Lordship will
No,
keep,
those are
keep on
settled.
record. I do not want to read.
No, no, those are settled. You cannot eject an unevictable tenant without fulfilling 51, 52. Oh.
So only Lordship, there are 34 and 35. Lordship will read. Court said 54 and 51. If you not complied, no suit. Now Lordship will sue.
Just a minute. Mr. Decker,
Hello.
though the observations in paragraph 18
9.
appears to be contradictory, but Mr. Sharma may be right. We are using the expression may, because where he has a Khatian with a particular number, you are only making an oral assertion that your Khatian is so-and-so with Dag number so-and-so. But there is no document.
Under this situation, my lord, there is the power under
The defendant's admission is on your ownership over the plot of land.
No.
But to make a comparison,
Sorry,
that
okay.
if you may,
Okay.
if
Then Lordship read. Then between the line, Lordship has read. I have not said that. Written statement is not that. Not that admission.
well-
And that admission, Lordship, I have a direct decision on that. That type of admission, Lordship cannot take hold of under that. I have a direct decision.
we'll see, we'll look into it.
Yes.
But before we criticize the findings in paragraph 18,
My lord.
before we make a
Because
criticism,
correct, before
19 has been explains 18, which Mr. Sharma has rightly pointed out that in absence of, we have one document, that is the defendant's document. To make a comparison, there has to be a document from your side also. Your document, your assertion is only oral. That my Dag number is, Khatian number is 283, Dag number 361. From where do you get? That A scheduled land, we are not on the Khatian number also, we are on the Dag number. There cannot be two now Dag numbers on the same plot.
my lord. Yeah, and
If his land, which he is describing, as your projection is made, that his Khatian will not save him because it's another plot of land. But to have that, and that to have that as a basis for passing any judgment, it has to be asserted that your Dag number.
Under the situation, my lord,
Yes.
the learned trial court as well as appellate court, my lord, section 75 of the CPC, my lord, there is the power of the commission, my lord.
But did you
So-
apply for 75?
My lord, the court is for the interest of my lord to get.
No, see, Amen
yes,
Commissioner
for the
would have been
demarcation-
appointed when 75,
the
did
court
you
will be-
apply?
That to commission whether this particular land is belong to that and my lord. the court for own interest, my lord, section 75 is very apparent, my lord. It is not necessary that either that we have to make application for commission, my lord. Since under such situation, since honorable specifically directed to ascertain these boundaries.
No,
so
if
exercising
you had a
faculty by-
if you had a document, a khatian,
my lord,
wherein your assertion of 283 and 361 was prima facie before the court, then issuing a commission is okay. But here, to make a comparison, there have to be two documents. There aren't.
to compare.
Compare with what? These are not oral assertion that my land is under so and so dog. Under what? What is the basis? You have to prove, have a document, some kind of a
Therefore, my
title.
lord, therefore, my lord, so I may not make such submission, my lord. My appellants approached me, my lord. I found him a very old person, my lord, and he said and cried me for me, my lord. I'm not, this is my emotionally, my lord, I'm making that submission. I will argue on my law. He stated, my lord, that he placed all the documents he has placed before his counsel, my lord. But all the round occasion, my lord, all these documents never placed. Those documents, my lord, he has given, yes, he is having all these things, my lord. With even appellate court also, though he failed to exhibit all these documents, under such circumstances, at least the court should ascertain the correct position of the matters. Court will send a commission. Yes, since I am having the one part documents, having the land documents in plaintiff has not. So commission will give a report on the basis of it. If to a distinguished land court, the court has not exercised despite having this power of CPC, my lord. The court ought to have section 75 years commission report under such circumstances. It is not the plaintiff. It is for court's interest, my lord. The court. It is true that no document exhibited from the part of the plaintiff, nil. And the defendant has exhibited go 1, 2, 3, my lord. Since this honorable admittedly sent it that to certain whether these two lines, in this situation, the court, Thanet Appellate Court, by exercising section 75 of the CPC for call for commission and to ascertain whether defendants possessing land, this is same or different, my lord.
See, leave aside everything. Let us proceed on the assumption that there is an admission that B schedule land is a part of A schedule, which is under your possession, which you are the owner.
Yeah. The assumption.
Now, let us assume
Yes.
A, you are the owner. Out of that, B, they are illegally occupying.
This portion, limited.
Yes, limited portion, but they have a Rayati Khatian. They have a Rayati Khatian.
In cross, it is objection, my lord. Though learned trial court recorded the article 13
No, no.
objection, but in the cross law, you will find independent one, my lord. Though they exhibited the Rayati Khatian, it's under objection, it is written in cross, my lord.
No,
But
right.
learned trial court recorded no objection. But we have, my lord, in the cross, the exhibit 4 does not, it is not a fact that the exhibit 4.
a fact.
No, I will come, my lord. It is not a fact that exhibit 4 does not relate to shoot land and non-examiner go photocopy. It is, and it is not a fact. No, my lord. I have not paid any money to the Master Babu plaintiff nor any plaintiff, and I have not obtained any permission from the town committee or any no objection from the plaintiff. But my lord, since this honorable court specifically directed to ascertain whether these two lengths are same or different, my lord. So my humble submission, my lord. Learned Appellate Court could have for commission and commission report, relying on commission report under such circumstances that interim judgment not passed, my lord. The same exercise has not been done. It is not necessary that plaintiff will, it is specifically directed to the Appellate Court by this honorable court. So it is the case again, my lord.
We have to go by the law. Law, under
Since
the,
law is available, my lord.
no, under the 71 settlement rules, one is entitled to get a
My lord,
khatiyan.
here, my lord.
No,
He is saving document, my lord.
listen to the
Dependent.
court, listen to the court.
Yes, sir.
He has a khatiyan, rightly or wrongly, he has a
My
khatiyan.
lord.
You have all the rights to challenge such a khatiyan, but it has to be specifically challenged. Your prayer is only for a recovery of khas possession. How he has entered, you have not even pleaded. He makes a defense that I have a rayati khatiyan.
My lord.
Rayati khatiyan is not the subject matter of challenge. You can evict even a khatiyan holder, but by following the provisions of 54, Red 8, 51 and 52.
That's a different procedure, my lord.
But you have not, so the khatiyan, not to talk about challenging the khatiyan, you have not even followed the procedure how to challenge a khatiyan. So khatiyan is there, as on date it is there. No court has said that it is the khatiyan is either bad in law or we interfere with the khatiyan. So on the strength of the khatiyan, he is still there. He admits that B is part of A.
My lord.
Let us assume that A, in spite of you not giving, let B a part of A, and A is you are the owner. But his khatiyan is still there, is a valid document. There is no
That is-
finding of the court
Yes,
regarding or not even an issue or a challenge made to the khatiyan.
yes, okay, absolutely.
So if khatiyan is there, it is not cancelled, how do you evict him? Khatiyan might have been obtained illegally or not by following, not following the due process of law.
To frame by the learned trial court, my lord, even the question lordship just, it is ought to have been discussed, this issue also not there, my lord. Then
No, issues will be framed only on basis of pleadings.
the right,
Court cannot on its own frame an issue. The pleadings, there has to be a dispute on the pleadings, and issues are what? Issues are resolution of the dispute.
my lord.
And what is a dispute? When there is a disagreement between the pleadings of one party and the pleadings of the other party. What is the point of disagreement? That is the issue.
Here the problem is, my lord, in the plaintiff is.
We go by the title of your suit, we go to the prayer of the suit. Nowhere you have challenged any khatiyan. There is no mention of any khatiyan. It is their defense. You could have amended the suit, or you could have filed a fresh suit with liberty, with relief.
Lordship, can it be fixed on tomorrow? I will take instruction, my lord, on that one.
See, these are long pending matters. My parties are old.
He's 85 years old.
Now, lordship, you will withdraw the suit. No, lord. I have a.
No, we have not even gone to the
No, you
extent.
said that you will take the instruction from the.
No, my question is different. Regarding that challenge, yes, that is open for me, my lord. That is open for me, my lord. Since this is that challenging of party is not the issue, that is open for me. Anything I
And
can challenge,
there
that
has
is
to be
right.
you just cannot go for a declaration for cancellation. He has to violate some conditions of the khatiyan. Unless you fulfill those three conditions
Now,
under the 71 Act, you cannot just,
lord.
those are termed to be unevictable,
My lord.
non-evictable
My
tenants.
lord,
It's a special right recognized for
I
riots.
understand, my lord. So first, my lord, the present case, the status of the present case is concerned. The simply petitioner's claim is recovery of past possession, only this is a question involved. And, my lord, then petitioner could have exhibited his ownership, exhibited whatever the document.
No, we are not even on the aspect
Yes.
of ownership, which
Yes.
Mr. Sharma
Yes,
is saying.
yes.
We are not even on that. There
Yes.
is an admission, we may not, but
Yes.
to make a comparison,
Yes.
that their
For
khatiyan
comparison, my lord.
is land, is for a plot of
For
land which is
comparison, my
outside.
lord, in this honorable code is paragraph 10, my lord, specifically directed to ascertain whether both these lands are same or different, my lord. Under such circumstances, the only option left remains for the court, Learned Trial Appellate Court below, to
Appointed commissioner. under
yes, my lord,
75.
to ascertain if it is different than matter of if it is same land, then that question. But same has not been done by the appellate court, my lord. As per the specific direction of this court, my lord. This is the question involved.
Okay, we'll
Not-
we'll continue tomorrow, not tomorrow, tomorrow to the problem. To matter like this. Tuesday can go both. Tuesday. Can we try on Tuesday?
Anything, lordship, I am at the disposal of the court. Lordship, but this is a case, lordship, I've seen, lordship. Otherwise, I should have considered, because lordship, what my learned friend is suggesting, lordship, 100 and 158 section in the CPC, and then there are 51 orders in the CPC. If the court have to give the advice to the client, file an application to this, do that, then is that not the job of the civil court? I don't think so. I don't think so, Lordship. 158 section and 58 orders in the CPC, and the court will give advice to the advocate that do this, do that. That's not the Lordship. And there are some, in the second appeal, there are some substantial question of law. Then going out of all the substantial question of law, you'll say compassion and all that, court have to look into it. No, my lord, it is not. And Lordship, on this point, Supreme Court is very clear. Lordship, because this is I said that this is third. After the second appellation, it is the third decree, Lordship. Then third decree, Supreme Court, this is on very clear, Lordship, 2019-11 SCC, these are not very clear, Lordship. The plaintiff has to prove his case to the satisfaction of the court. He cannot succeed on the weakness of the case of the defendant. Even otherwise, there is no confusion at all regarding the identity of the property in question, which is my case, Lordship. And on the basis of the material on record only. Then the first appellate court has certainly ruled that the defendant appellant has proved his title and possession over the suit property, since the defendant has shown some title document, Lordship. In my case, it is not there. Date of his purchase of the property. Prior to the purchase, the predecessor interest was in possession of the same. The conclusion arrived at the High Court and the reasons assigned for the same are not correct, in as much as there is absolutely no material in favor of the case of the plaintiff to show possessory title. The order to claim possessory title, the plaintiff have to prove his own case. And also will have to show that he has better title than the other person. These things are not there in this case, Lordship. And then, Lordship, this High Court judgment, Lordship, it is very clear, para 35, it is very clear that no court can show this compassionate type of thing. This is not a compassionate appointment, Lordship, this is a civil suit. The para 35 is very clear. In view of the discussion above, the appeal is partly allowed by holding that the plaintiff is not entitled to get recovery of first possession of the suit land by evicting the defendant therefrom. Because 35 said the 54 and 51 is not complied, so not. And accordingly, the substantial question was decided in this. It's a second appeal.
Okay, Tuesday we'll have. Tuesday you are around, Mr. Sharma? Tuesday?
Yes, in a convenient court.
Paucity of time did not permit the matter to be, did not permit hearing of the matter to be completed today. First up, list for further consideration on Tuesday.
My lord, deep look,
11/6.
deep look.
Right. You can.
Hearted land close. At least that part.
We've said further consideration.
Yes.
Deep look.
My idea.
I'm grateful.
Okay. এইটো আগত ONGC টো দিব লাগিব ONGC যে আছিল
Ma'am,
yes
the appeal has been filed against the order dated 1/12/2020.
item number
Item number 13.
13
The day before yesterday, they were proposed to dispose of that. And
Yes.
That
what was the issue? Well, others may go, rest of the matters will not have. This is the last matter. What is the matter about?
well, plaintiff's ad injunction was rejected by the trial.
Okay, oh yes yes
And FA was filed,
okay
and the FA status was done.
okay.
And there is an order 18/1/2023.
Mr. Sensor, your matter is similar matter. Ad interim something. Okay, you may remain. I think that we'll adopt that procedure. Is it okay? Just give us the basic facts, Mr. Das. Appellant is the plaintiff.
A plaintiff. There are three plaintiffs.
Three numbers. Suit for
Good for a specific purpose of content.
an injunction.
In the
And
order of the civil judge, lordship, page 102, our injunction petition was rejected.
102.
102, last page.
102. This is the appellate court. Okay, first appellate court. 102. That means which was the one? What was the trial court?
Civil
Trial court
judge.
was which court?
Civil judge.
Civil judge, senior.
Senior division.
Senior division.
102.
The list of the cases there, lordship.
100.
102.
Okay. Is it 112 2012?
112, 2012. 22.
22 under 2022. Yes. Art Swenson for grant of leave to accordingly granted. 102. Yes. Applicant consider.
Fixing a long date.
Okay.
Only issuing.
Okay. Ad interim injunction.
Yes.
Only notice has been issued.
Notice was-
Okay. When is the notice issued? On ad interim injunction. Now, what is the date when High Court has passed status quo?
18/1/2020.
18?
1/2020.
18/1/2023. Status quo. Continuing. Suit is also halt at a halt.
Because of
And there is an observation also.
Hmm. What is the observation? This status quo is in the IA.
In last paragraph of the order, it is made clear that the pendency of the instant appeal as well as the injunctions for granted by this court shall not debar the trial court to proceed with the injunction proceeding in accordance with law. As per that direction,
But has it proceeded? No.
no, defendant filed their
Objection.
supplementary file is open, but no effective order has been passed as the record has
Okay, we'll close this then.
Yes, sir. That may be remanded back.
Okay, okay. Yes, yes.
until passing any further order.
Yes, yes,
by-
yes. Right. But we'll fix a date. You have filed objection?
Yes, already.
So for my inspection, tomorrow is
Tomorrow they'll not get the order. Maybe a short date will be fixed. Tomorrow you inform the court. Okay. Hertz, 3 J Das, Learned Counsel for the appellant. Full stop. Also heard 3 N Hawk, Learned Counsel for respond number 3. 1 and 2?
1 and 2, my lord,
did not appear.
3, whereas 3 Bhattacharya, London State Council accepts, is present for respondents, for the official respondent, for the state respondents, full stop.
Proforma depend.
Huh?
Proforma depend.
State respondents, we invite proforma respondents. State Council for the proforma respondents, huh? Para, considering the subject matter involved and as agreed to by the learned counsel for the parties, comma, the instant appeal along with the concerned, along with the connected IA are disposed of by this common order, full stop para. The appellants are the plaintiffs in the suit filed for specific performance and for injunction. Full stop. Along with the said suit, which was registered as title suit number 134 of 2022, comma, Ms. J case number 198 of 2022 was filed for injunction, full stop. However, comma, wide the interim, avoid the order dated 1/12/2022, comma, the prayer for grant of ad interim injunction. However, by the order dated 1/12/2022, comma, only notice was issued on the, in the interim, in the application for injunction. Full stop. Para, being aggrieved, comma, the present appeal has been preferred along with the connected IA. Full stop. Para, it transpires that this court, by order dated 18/1/2023, had passed an order for maintenance of status quo as regards title as well as possession. Full stop. It was also, however, made clear that pendency of the appeal as well as the injunction granted by this court would not debar the trial court to proceed with the injunction proceedings in accordance with law. Full stop. Para, the learned counsel for the rival parties have, however, have informed this court that in the injunction application, comma, objections have been filed, and the next case is indeed fixed tomorrow. Tomorrow? Next case is fixed shortly. Full stop. Para, this court has noticed that more than a year has passed of passing of the order of status quo, and in spite of the liberty granted by this court to proceed with the injunction proceedings, comma, it appears that the said application for injunction has not yet been disposed of. Full stop. Not yet been disposed of, most likely because of the pendency of the present appeal. Full stop. Para, since this court has also been apprised that the defendants have filed objection to the injunction application, comma, coupled with the fact that till now the appellant's plaintiffs are protected by an order of status quo, comma, interest of justice would be served if the appeal is closed with a direction to expeditiously consider and dispose of the injunction application, which has been numbered as Miss J case number 198 of 2022. Full stop. The parties may accordingly approach the learned trial court with a copy of the present order, whereafter the learned court will fix a date for, we will expeditiously consider the matter and dispose the same expeditiously, and preferably within a further period of 3 months from today.
And till then, the status
since this court, by the initial order dated 18/1/2023, had passed an order of status quo, comma, till such disposal of the injunction application, comma, the order of status quo be maintained.
So, may I pray this status quo order not affecting pass that not
Obviously,
both the parties are staying their position.
the decision to be taken by the trial court would be uninfluenced by the order of status quo passed by this court.
only Miss case, not Miss J. J is wrongly.
J na lage. We'll check it out. Mr. Sensor, give the numbers and quote.
Item 15, ma'am.
Same. Give the numbers and the quote. Who's for the other side?
It was here, but
Just that, my lord, in my matter, my lord,
Item number?
item number 15, my lord,
Okay.
the order passed by this honorable court is on of 4/8/2023 in the IA.
Mr. Saikia was there. Where is he?
Yes, my lord, it was there. Okay.
We'll have it tomorrow. But tomorrow you mentioned this matter.
My lord, in the
Okay,
morning, my lord.
We'll upgrade and take it up.
Well,
Uh,
I mentioned the morning.
Yeah, make a mention. Both of you come. And try to have we'll have a copy of this order. We'll hand it over to you. Just make the necessary changes. We'll have the same order.
Hello. Bibliography.
Paucity of time, sir. List again tomorrow. Liberty is granted to the Learned Council to make a mention for upgradation. Okay.